Good afternoon. Welcome to the Appellate Division First Department oral arguments for today, April 7, 2021. I will now call the calendar. Please be reminded to keep your mics muted unless you are in fact speaking. People versus William Merritt.
Good afternoon, Ronald Zapata with legal aid for Appellant William Merritt.
5 and 1. People.
Good afternoon, Claire Nielsen for the People.
Thank you. 5 minutes. Gaston versus New York Department of Housing.
Good afternoon, Hashim Rahman here for the appellant.
6 minutes.
Good afternoon, Elizabeth Friedman appearing for Respondent.
6 minutes. Edward versus Latoya is submitted. Enriquez Rodriguez versus 160 West 118th Street.
Good afternoon, Chris Theobald on behalf of Defendant Appellant 160 West. 7
minutes.
Good afternoon, Stuart Diamond on behalf of the Plaintiff Respondent.
7 minutes. People versus Luis Robles is submitted. Ambase Corporation versus 111 West 57th Street.
Your Honor, Eugene Myers on behalf of the appellant, and I'd like to make an application for my co-counsel Haley Proctor, who has been admitted pro hoc vice to argue on behalf of appellant.
That's granted. 6 and 2.
Thank you.
Thank you.
Respondent.
Good afternoon, Judge. Mark Wolfish for Respondent.
6 minutes. Bny Mellon versus Feldman.
It's Paul Weinstein for Bny Mellon.
5 minutes.
Jeffrey Metz for the Respondent Feldman, Your Honor.
5 minutes. People versus James Smallwood.
Emma Schriefter on behalf of Appellant Smallwood.
4 and 1.
Thank you.
Shane Magnetti on behalf of the Respondent.
4 minutes. Sadi versus 315 East 68th Street. I just have a respondent on that. Respondent? Fritz versus JLG Industries.
Jacqueline Silver appearing on behalf of JLG Industries, the defendant appellant.
So you have 5 and 2?
Correct.
Who's next?
Good afternoon, Jamie Regan on behalf of United Rentals.
5 and 2.
Thank you.
Next.
Good afternoon, Adrian Uron on behalf of Appellant MTA and TBTA.
4 and 2. And then we have 2 respondents.
Yes, good afternoon, Howard Sanders for Carl Fritz, Respondent and Plaintiff.
4 and 2. And then we had a late request from counsel for O'Keefe.
Thank you, Your Honor. Joseph Kraft on behalf of Richard O'Keefe, Plaintiff Respondent.
1 minute.
Thank you.
Cruz versus MTA is submitted. People versus Waldine Elliott.
Harold Ferguson for Appellant Waldine Elliott.
6 and 2, Mr. Ferguson.
Yes, Your Honor.
Susan Gleiner for Respondent.
6 minutes, Ms. Gleiner.
Thank you.
APS Contractors versus NYCHA.
Good afternoon, Your Honor. Gil Namias for New York City Housing Authority. Your Honor requested 8 minutes. Can we have 5 and 3?
Yes, certainly.
Good afternoon. This is Melissa Celsano with Bakar and Abramson on behalf of Respondent Cross Appellant APS Contractors.
You do have a cross appeal, so that's 8 and 5.
Thank you.
Diaz versus HHCTS Wright.
Lauren Donnelly for the Appellant SJ Electric.
6 and 2.
Thank you, Your Honor.
Respondent Paul Maloney, Edelman and Edelman for the Plaintiff Respondent.
6 minutes.
Thank you, Your
Honor. Tudor Perini versus City of New York.
Good afternoon, Jim Barriere for Appellant Tudor Perini.
7 minutes.
Lorenzo De Silvio for Respondents, Your Honor.
7 minutes. 400 East 57th fee owner versus 405 East 56.
Yes, Bencio De Funes for Appellant 405 East 56th Street LLC.
5 minutes.
Howard Coe, Meister Seelig and Fine for Respondent.
5 minutes. Chester County versus Ison Pharmaceuticals.
Good afternoon, Your Honor. Alex Stryluski from Skadden Arps for the appellants. I would respectfully request that my colleague, Michael Hines, be given permission to appear pro hoc vice to argue on behalf of appellants.
That is granted. You have 7 minutes.
Good afternoon, Your Honor. Michael Hines. Could we have 6 and 1, please?
Yes.
Thank you very much.
Respondent.
Doug Willens for the Respondent, Chester County Employees Retirement Fund.
7 minutes.
Thank you.
Mintz-Frade Law versus Federal Insurance is submitted. And Sadi versus 315 East 68th Street.
Good afternoon, Your Honor. I apologize. This is Respondent Meredith Cavallaro for 315 East 68th. I had a issue with my mute button before.
That's fine. 5 minutes. Thank you. So as you can see, we have a very long calendar. We have almost every case is going to be argued. So I'm going to really ask and ensure that you abide by the time that is allotted. If you find that you need less time, that is always appreciated as well. Please remember not to speak over the justices. If we have a question, we will certainly put it to you. But again, keep your mics muted, and we shall proceed with the first case, People versus William Merritt.
Yes, good afternoon, Your Honors. Ronald Zapata with the Legal Aid Society for Appellant William Merritt. Because the complainant here admitted to taking at least 3 to 5 minutes before calling 911 and had the opportunity to reflect before making the call, the 911 call cannot be considered a present sense impression. The Court of Appeals decision in People v. Dalton is controlling. There, a 911 call was made 1 to 5 minutes after the incident that the call described.
Counsel, Judge Singh, let's assume you're correct on this issue. Isn't there overwhelming evidence here of guilt?
No, Your Honor, there is not overwhelming evidence for 3 reasons. First, the jury requested to listen to the 911 call twice during deliberations, therefore showing that the 911 calls had a significant part in their deliberations. Secondly, the 911 call was the only evidence that appellant purposely displayed the box cutter he was allegedly used here.
But didn't he admit to his grandmother on a call that he in fact possessed a box cutter?
Yes, he admitted to possession.
Was the box cutter found on him by the police officers?
But for both the weapon possession charges and the menacing charges, possession isn't the only thing that had to be proven. What was required is that the people had to prove beyond a reasonable doubt that appellant intentionally displayed the box cutter. And
I'm sorry, Counselor, did I misread the record? Did the complainant not testify?
The complainant did testify, but
and the complainant is the same individual who made the 911 call where you stated that the court incorrectly admitted as a present sense impression. Is that correct?
Yes, correct, Your Honor.
And so when the complainant testified, was he not also cross-examined by counsel? And so that any inconsistencies between what he stated in what you argue would be the incorrectly admitted 911 tape, was he not cross-examined as to what was stated in that 911 call and his testimony at trial?
Yes, he was, but however, I'm not raising a confrontation clause claim.
You're raising an unreliability, right? Because it's hearsay. So you're stating that because it's hearsay, it was unreliable because he had an opportunity to reflect. Is that correct?
Yes, Your Honor. But
with his testimony at trial, and with the fact that counsel was able to cross-examine him, would that not do away with any issue as to his the unreliability of his statements, wherein he was subject to cross-examination at trial as to exactly what occurred or did not occur?
No, Your Honor. And the key here is his testimony at trial was different from what he stated in the 911 call.
How is it different?
The 911 call, he stated that appellant pulled out a knife. And that was the only evidence presented at trial that appellant had intentionally displayed a knife. Now, at trial, the complainant testified that, quote, I caught something in the lights. I caught something shiny. He never stated anything about some intentional display. He said that he saw something shiny at appellant's side. Never said he ever saw anything in appellant's hands. Never stated that appellant ever made any kind of threats involving a knife. Never said that appellant ever stated, I'm going to slash you, I'm going to cut you, or anything of that sort, or even stated, hey, I have a knife.
So again, would counsel not have had the opportunity, and I believe he or she did have the opportunity, to question the complainant regarding these inconsistent statements, and also to argue to the jury on summation as to the inconsistencies and the fact that therefore the complainant would be incredible or not credible, and therefore they should not credit his testimony, and therefore they should acquit the defendant?
But there's a problem here, is that the two different the difference between the testimony and the 911 hearsay. So because he testified differently, as the jury saw it, there were problems with his credibility. So they went to the 911 call, listened to it twice, and hearing there that there was some intentional display, they could find that, hey, we're going to credit the hearsay from the 911 call over.
Counsel, based on the victim's testimony, why wasn't it sufficient for the jury to conclude, given with all the other evidence, that in fact defendant did display something shiny, i.e. some kind of weapon?
Because well, you could see from what the evidence that they asked to look at during deliberations. They asked for the 911 call twice. They didn't ask to hear his testimony.
Well, they already heard it. They heard it, right? They didn't need to hear it again.
And they could have requested it again, but they requested to hear the 911 call twice because it's so important in their decision, because his testimony did not show that there is some intentional deliberate display. And therefore, without the 911 call, the only evidence showing indicating that my client had actually intentionally displayed a knife, there's insufficient evidence that of an intentional display.
You have 1 minute on rebuttal. Thank you. People?
Thank you.
Good afternoon, Your Honors. Claire Nielsen for the people. First,
so does the fact that the jury asked for to hear the 911 tape on 2 occasions, does that mean that they place greater emphasis on that 911 call as opposed to the actual in-court testimony of the complainant?
No, not at all, Your Honor. The jury did ask to listen to the 911 call twice, but they also asked to review the security footage twice. And really, it just means that they were carefully reviewing the evidence presented at trial, and ultimately they decided to convict defendant. So we can't speculate on what their reasoning into asking for it twice was. But defendant's arguments regarding the timing of the call are unpreserved. The only claim defendant preserved was that the time interval between the incident and the 911 call was 3 to 5 minutes, or at most 6 minutes. His arguments on appeal.
But counsel, that sounds to me that the objection's preserved, because what else could it? It's the argument is it's attenuated and shouldn't come in, no?
Well, the time on appeal, they were arguing it could have been 8 minutes or 10 minutes, 11 minutes, and these were all very new arguments. So it was preserved that it was 3 to 5 minutes, or at most 6 minutes. But again,
well, that was based upon the time stamps on the video and the 911 sprint, right? So because of that, it was estimated that it was about 6 minutes, wherein I think the judge said that means that takes us to about 6 minutes, and complainant had testified that it was actually maybe 2 to 3 minutes, something of that nature. So, I mean, we don't know, there really is not that much certainty other than actually comparing the timestamp on the surveillance with the 911 sprint, right?
Yes, and there was no evidence presented at trial that those 2 different clocks were even in sync with each other. But regardless, the trial court correctly found that the call was contemporaneous to McMurray's observations and was corroborated by.
How can you say that? He walks down to the end of the block. Doesn't he have an opportunity to think about it? It's not sort of a spontaneous act, no?
No, it was spontaneous. He did walk to the end of the corner, but again, he was removing himself from this heated confrontation where a blade was displayed, right in his face. So it wasn't enough time to reflect. He did.
I thought obviously he reflected, and he even admitted that he reflected because he testified that he was, kind of torn as to whether he should call 911 or not call 911. So that by definition is reflection, right? He's thinking about it. Is it really something that I want to report? Do I not want to report it? Should I report it? And then he testified, I believe, well, maybe I should report it because this guy may be dangerous and they may do this to somebody else. So obviously there was some reflection as to the incident, because he reflected on whether he should or should not report it.
He paused when deciding to call 911, but he was not reflecting over what had just transpired. And this type of reflection, if you want to call it that, when he was deciding to call 911 was not the type of reflection that the courts need to be worried about when admitting a 911 call as a present sense impression.
Why was it not reflection as to the seriousness of the incident? Why could you not argue that that's what he was reflecting on? I mean, if it's something that is so serious, he's going to call 911. So why would you not argue, or why could you not argue that obviously he was reflecting upon the seriousness of the incident, and that is what made him decide, gave him some thought as to whether he was going to call 911 or not call 911.
I think his testimony really just showed he was mulling over, do I call 911 or do I not call 911? And anyone who calls 911 had to pause and think to call 911 and make that action. So that's not enough to amount to reflection. Assuming this was error, is there a harmless error analysis, and was there other proof of guilt? Yeah, there was overwhelming evidence of guilt, even without the 911 call. Any such error in admitting it was harmless due to the strength of the other evidence presented. The evidence conclusively established that defendant was holding a box cutter. We know defendant had a box cutter. The arresting officers found a blade on him minutes after the incident. The surveillance video showed that inside the restaurant, defendant was reaching for something in his pocket when first speaking to McMurray. And then outside, we see on the video him reaching for the same pocket and holding something. McMurray testified in court that he saw a flash and saw what he thought was a knife at the time, and it was obviously a box cutter here. So additionally, we do have the 911 call, but if the court found not to admit that, that error was harmless due to the overwhelming evidence here.
What about the inconsistency?
I'm sorry, go ahead.
That's okay. I'm good. We can move on.
Thank you, Counselor.
Okay, thank you.
Zapata, you have 1 minute.
Just regarding the harmless error question, the ADA says that there is overwhelming evidence. Here, it's very important to note that the surveillance video, absolutely no evidence in the surveillance video of my client holding a box cutter at all during this incident. Not at all. And there are several parts in the video where you could see him with an open palm and in front of the camera, and there's no evidence at all of him looking at.
Counsel, there's testimony of the victim. There's a box cutter found on the defendant, and also there's an admission.
There has to be an intentional display. That's a crucial element.
The flashing of something shiny is not an intentional display?
No, because he said he saw something reflect in he caught something in the light, something shiny at his side. Caught something in the light is not someone intentionally displaying something or saying, I have a knife, I'm going to cut you, I'm going to slash you. That's the type of intentional display that has to be proven for a menacing or a CPW3 charge, as is alleged here. So, and that evidence was not here, besides a 911 call. And so, without a 911 call of the allegation of an intentional display of pulling out the knife, there's no evidence here of an intentional display.
Thank you, counsel. Thank you very much. Thank you both. Next matter is Gaston versus New York City Department of Housing Preservation and Development.
Good afternoon, Your Honors. May it please the court. My name is Hashim Rahman. I appear on behalf of the appellant Gaston today. The appellant commenced the underlying action against the Department of Housing Preservation and Development, or HPD, because the agency did not produce records responsive to her Freedom of Information law request, which I'll refer to as the FOIL request.
The agency stated that given the confidentiality issues, that they were not able to supply all of the records, that they could not do it electronically, that they had to do it manually, and they asked for payment by your client of, what is it, $2,500, something of that nature, based upon the copying of this voluminous record. So 10,000 pages of documents would be responsive, and they asked for payment of 25 cents per page.
Thank you, Your Honor. First of all, I asked the HPD's counsel whether those 10,000 pages were even responsive to the FOIL request. And I quote, she told me, "I don't know if these are technically responsive to your FOIL request." So asking us to pay $2,700 after 2 months after the action commenced, without telling us whether those 10,000 pages are even responsive to the FOIL request, seems a bit off. We shouldn't have to pay for documents that we didn't even request. And
wasn't your request a little broad as well? Didn't you ask for any and all documents relating to the mold?
We asked for documents pertaining to tenant complaints, inspection reports, mold complaints, and court filings, and documents related to that within a 6-year time period.
Well, for the entire building, correct?
It was for the entire building.
So that sounds rather broad to me. So you're going to get what you asked for.
Well, the thing is, the agency never responded to our administrative appeal. So they never responded to that appeal. During that administrative appeal under Section 89(4)A of the FOIL, that was their opportunity to tell us why they're not presenting the records. But they completely ignored the administrative appeal, and they raised any arguments 2 months after we expended costs and attorney's fees to file the FOIL request.
Counsel, you already received a great deal of information by way of the summary reports, which are the reports that are typically used by the agency. The summary reports contain a substantial amount of information, date of complaint, date of inspection, date of violation of any, or the case, no violation issued, a description of the actual problem. And it's very easy for you, for example, to discern from those reports, I would think, what you needed and what you did not need. But you did, as my colleagues are saying, you made an extremely expansive request by asking for the backup documentation that supported those summary reports. Isn't that a very unusual FOIL request? And as my colleague said, didn't you get what you asked for?
Well, Your Honor, this is not a very big building, and we didn't expect there to be over 40 or 50 different complaints and violations for this building. So there was a lot of complaints that were listed in that summary. But what's notable is we didn't even receive one single tenant complaint. We didn't even receive one single notice of violation, one single summons that describes the issue against the buildings. What we have is just a data entry record, just listing every single document that they have, but we didn't receive the underlying documents.
Counsel, I took a look at those reports. Those reports are expansive. If there's no tenant complaints, are you suggesting that there's tenant complaints that are not entered into the reports and that do not result in inspections? Because I don't understand the breadth of your query.
Well, Your Honor, if I could direct your attention to page 40 of the record, which lists just one-line entries of the complaints. Those are the tenant complaints, and there's not much information for any of those listed there.
You received from HPD effective April 2019 open violation summary reports, closed violation summary reports, and complaint history reports. That's quite a lot of information. If you're saying what you wanted to find wasn't there, Could that possibly be the answer to your query?
Well, they never even certified that it wasn't there. There's over 40 or 50 complaints listed on the complaint summary, and those are just one-line data entry. And we didn't even receive any of those. So perhaps if we received some of those, it could have been a starting position for a discussion. But given that we received essentially a data entry document that you can go to your computer and pull up, typically with the absence of a FOIL request, we needed more for this case.
And because it was going to cost 25 cents a page for 10,000 pages worth of information, wasn't that your choice as opposed to HPD's choice as to whether the value of this information was adequate for you?
Well, Your Honor, I cannot stress any more that they never determined whether those 10,000 pages were responsive to the FOIL request. In the record, I specifically show the emails in which I asked them, can you tell me if those 10,000 pages are responsive?
But I saw, but yeah, right. But I saw that. But I mean, I was thinking, do you have to go down there to look at the information yourself? Could you have done that? But there was a confidentiality issue here, wasn't there? Didn't there have to be a redaction of information first in order, for example, hypothetically, for you to go look at it? Did you even make a request to go look at it yourself? As an attorney, counsel at law.
The sequence in which this occurred is 2 months after the Article 78 action was filed. I received the information from the attorney saying, well, we have these 10,000 pages of records, and they said, we're not sure if it's responsive. The very next day, they filed the answer indicating that we refused to pay for the records. So I was still waiting for some kind of response saying anything about whether they were responsive. And yes, one of the options, if we were negotiating further, and even if the court held a hearing, I would have been happy to have gone to the office to look at the records so we can narrow what we really needed. But they didn't provide any determination of what was in those 10,000 pages and whether it was responsive to the request. And it happened 2 months after we filed the action.
Thank you. You're out of time. Yes, Respondent.
Good afternoon, Your Honors. May it please the court. My name is Elizabeth Friedman, and I am appearing for the Respondent, New York City Department of Housing Preservation and Development. Your Honor, the HPD certainly complied in full with the FOIL request. If you look at the request itself, that's at page 62 of the record. The petitioner is seeking all records pertaining to inspection reports generated or issued by HPD within the past 6 years.
So your adversary just stated that even though you said that there may be these 10,000 pages that you never really specified or stated whether or not they were in fact responsive to his request. So is that correct? And if so, why not?
Well, Your Honor, we contend that the documents we already supplied prior to the Article 78 proceeding, the 28 to 30 pages of the open violation summary report, the closed violation summary report, and the complaint history report were responsive to the FOIL request. Later, the petitioner requested these additional underlying documents. So basically, they're voluminous, and HPD's counsel said, we will provide them. They have to be redacted, but we have to make the record, and it's impractical to do this by email, and we are charging 25 cents per page, which the statute offers.
I understand that, but the question is, did you also state to counsel that you have to pay the 25 cents per page? However, these documents are definitely responsive to your request. Or did you say maybe only 5,000 are responsive to your request? We're not really sure, but you have to take all 10,000 and you have to pay for all 10,000.
Well, to the extent that the petitioner was seeking the underlying documents, to that extent, in the addition to the other documents, it was 10,000 documents. And basically that statement, we don't know whether it's in response. The counsel for HPD said, basically, it doesn't contain much information. It's not very interesting. All of the pertinent information is in what you've already received. So it was basically in the nature of, he's asking if it was, to the extent he's seeking the underlying documents, the notices of violations, the inspection reports, the repair invoices, the complaints, the underlying complaints, the violations, it's responsive to his request for the underlying documents. we already complied with the FOIL request. And in fact, later when he indicated that he was interested particularly in mold complaints and particularly with regard to complaints related to apartment 25B, HPD then turned over an additional 16 pages, and that's in the record as well. So basically turned over the information that it had based upon what petitioner indicated he was interested in. So in terms of whether or not they're responsive to his additional request above and beyond the FOIL request. Now, HPD was willing to put in the time and effort to do that, but also HPD is authorized under the statute to charge 25 cents per page for redactions. The petitioner does not claim that he's entitled to see unredacted documents. The redactions would have to be done for privacy considerations. And in fact, it's a voluminous number of documents. So the statute particularly specifically authorizes HPD to charge 25 cents per page. And we think that's a reasonable amount for to produce these records, which are not already maintained in redacted form, to turn these over. If in fact the petitioner wants the whole universe of these documents, which we also pointed out to him, the information he's seeking is in the 30 odd pages that we've already provided to him, the relevant information. If he narrows his request further, we can speak to him about that. But certainly we can produce 10,000 documents, but it has to be redacted and they have to be pursuant to the payment of the cost for those documents.
Thank you.
Thank you, Your Honor.
Anyone else have any questions? Any questions? No. Thank you very much. Thank you both.
Thank you.
The next matter is Enriquez Rodriguez versus 160 West 118th Street.
Good afternoon. My name is Chris Theobald of Shaw, Bomany, Citron, and Spratt on behalf of Defendant Appellant Respondent 160 West. The crux of our appeal is that the jury's awards for lost earnings and pain and suffering were excessive. The lost earnings award was excessive because it was totally divorced from any of the documentary proof of plaintiff's earnings that was introduced at trial. It's about triple.
The plaintiff was 28 years of age at the time of the incident, right?
I believe that's correct, yes.
He produced, I thought he produced his tax return. Did he not, for a couple of years?
He produced 4 years of tax returns, that's correct.
And why is it that you're stating that what was produced was insufficient?
Well, it's not just that what was produced was insufficient. The award was untethered to the figures reflected in those returns. So just to take
what about counsel, his testimony? Couldn't the jury consider his testimony as well in making a determination as to whether or not lost wages were established with reasonable certainty?
Well, clearly they did consider his testimony. In fact, they exclusively—
I know, I understand that, but could they have considered the testimony?
I don't think so, because it was contradicted by the documentary proof. In other words, just to take a concrete example, if you take the 2012 tax return, which was the year before plaintiff's accident, the net income reflected in that return is $10,820. The annual earnings assumed by the jury in reaching its award was about $33,000, so more than triple that amount.
Well, let me ask you, why would we consider net income as opposed to gross income, given that he's a wage earner? He doesn't have a business with expenses. Why would that go into the equation?
Well, actually, he was deducting business expenses. That's how we got his net income. But even if you were to use his gross income, I believe that figure was $16,000. That would be less than half of the figure that the jury assumed. So either way, you're looking at a massive inflation of the figures reflected in the tax returns.
Can you address the collateral source controversy?
Certainly. So the crux of our position on that issue is that plaintiff testified at his deposition that he had applied for Social Security disability benefits.
And that deposition was in 2016, correct?
That's correct.
Okay, when was note of issue filed in this case?
Let me see. Let me check for you.
It was sometime after that, right? 2018, 2017?
I believe it was shortly thereafter.
Okay, so did you move to vacate the note of issue saying, I don't have this, the letter that I demanded at the deposition?
Yes, the note of issue there was a motion to vacate the note of issue.
So that would be the point for you to address the issue that you didn't receive a document that was demanded at the deposition, correct?
Yeah, that's correct.
And then what, did you ask for the document? I mean, it's not clear from the record and the arguments what occurred, but.
Right, we weren't handling the case at
Well, it
that
doesn't
point.
really matter.
Of course, it doesn't.
So why should you at this point, after the trials occurred, be able to revisit the issue of discovery because a note of issue has been filed and you agreed the discovery was complete?
Well, there was no explanation for the failure to respond to the discovery demand.
I understand that, but you understand what the rules are, right? You have 20 days to move to vacate. After that, you have to show unusual or unanticipated circumstances, et cetera, right?
Mm-hmm.
And have you done that here?
The record is unclear on that point. The only thing I can say is that it's clear that there is a reasonable probability that plaintiff is receiving collateral source offset. And there is authority permitting post-trial discovery on this issue.
Well, but you're talking about the second department case, right?
That's correct.
Which is in some conflict with our case law. Putting aside the issue of what the standard is, just on the issue of getting discovery. Because I frankly don't see how it's unanticipated. I mean, you knew back in 2016 and you do nothing about it. You don't even presumably file a trial subpoena asking for that document, do you?
I don't believe so.
Okay.
This is Justice
Sure.
Shulman. I'm sorry. You're challenging the reasonableness, or rather the unreasonableness of the compensation for past and future damages for pain and suffering for his injuries. He was 28 years old, he's in his 30s now, and the record is clear, as I understand it, that the jury got to hear expert testimony about the permanency of his injury of his hand, that there was testimony that he couldn't even handle a sedentary type job in terms of his, and of course you heard testimony of the pain that he suffered from for all these years, where with each successive surgery, there was some attempt to try and remove more nerves. And actually, if he had gone through the most recent surgery, which he didn't go through, would have actually made him incapable of moving his hand, in a certain direction permanently. So against that backdrop, why would you believe the compensation for past and future is unreasonable?
Well, when comparing this case against similar cases, it's just wildly out of whack with the range.
Well, did the case that you cite have both the nature of his wrist injury in addition to the back issues that are also here? I mean, did the cases you cite, are they on point for the very type of primary injury that this plaintiff suffered from?
There is one case that is almost identical, although it's slightly worse, and that's Diouf. That's a 2010 case. We cited that in our brief. In that case, this court approved a $1 million pain and suffering award for a plaintiff who fractured both wrists, had 2 surgeries on his left wrist, no surgeries on his right, and he could no longer work after that. So again, that's a $1 million award. We would say that based on this and other cases, the sustainable range for this constellation of injuries, which is, as you said, a severe wrist injury and a back injury that does not require any surgery, we would say the sustainable range for that, based on these cases, is from the mid 6 figures to the low 7 figures. And the award here is about double the high end of that range.
Thank you very much, counsel. You're out of time. Thank you.
Thank you.
Respondent?
Good afternoon. My name is Stuart Diamond. I'm here for the plaintiff respondent, John Enriquez Rodriguez. There was actually practically all of the evidence as to damages, including the evidence as to lost earnings, at trial was undisputed. It was undisputed that Mr. Enriquez Rodriguez suffered a scaphoid fracture of his dominant wrist, that was a particularly problematic type of fracture because of the low blood supply to that part of the wrist. He underwent 2 complex surgeries before the trial. He was to undergo 2 complex surgeries after the trial involving bone grafts and severing of the nerve. The first procedure was unsuccessful. That resulted in having to remove the bone altogether. The last procedure, which the doctor said would be performed, would result in permanent pain and a permanently deformed hand. He could not move his hand at all from side to side. All of that was undisputed. It was undisputed that he sustained 2 bulging lumbar discs and stenosis that was causally related to the.
So, counsel, could you discuss the issue as to the collateral source, because your adversary stated that the record was unclear as to exactly what occurred as to whether they did or did not move to strike the note of issue based upon the failure to turn over information as to collateral source.
They did move to strike the note of issue. That motion was decided. I believe it's document number 66 on the e-filing docket. I'm looking at the order right now. It's dated May 9th, 2016. It did not require the plaintiff to provide any collateral source discovery. They did not move to re-argue. They did not appeal. That's law of the case. That was decided. And this court's ruling in Stolowski said,
Is there, maybe technically you're right, but is there some sort of unfairness where your client may be receiving benefits that should be offset? And is that something we should consider in deciding whether or not to grant collateral source hearing at this juncture?
I don't think so, because his testimony at trial was that he wasn't receiving any collateral source benefits that didn't have to be reimbursed. And that's the reason why the CPLR and this court's decision require that the discovery be conducted pre-trial.
But didn't he testify that he had applied for, but there was no there had not been a final determination? Wasn't that what he testified to?
That's what correct. That's what he testified
to.
So
it could well be that he would be receiving and perhaps at this point in time is receiving.
It's possible, but that's why the rules require that the discovery be conducted pre-trial. So on the pain and suffering, the one case that counsel mentioned during oral argument, Dio, he doesn't mention that the plaintiff in that case was 55 years old. If you prorate the award by his life expectancy, which they consistently neglect to do, the award to the plaintiff in Dio was actually 48% higher than the yearly award that was made to Mr. Enriquez Rodriguez.
Counsel, can you address lost earnings? You say there's no inconsistency, there's no dispute about it, but isn't there an issue as to how many days a week your client was working?
No, he testified, and I could read you the testimony verbatim. He testified.
Counsel, didn't your client testify that he worked 5 days a week, every week, as opposed to what his coworker testified to, which is that they worked as many as 3 days, at most 3 days a week?
No, what the coworker testified to was that he and Mr. Enriquez Rodriguez would sometimes work together only 3 days or 4 days a week, and sometimes 5 days a week. Mr. Mendoza did not say, even though they say this, he did not say that Mr. Enriquez Rodriguez only worked 3 days or 4 days a week. All of that testimony, which is cited verbatim in our brief, was about whether the two of them worked together 5 days a week.
Counsel, wouldn't the tax returns be the best evidence, I guess, of what the lost earnings should be?
Well, we cited, and in fact, they concede this in both of their briefs. We cited, and they cite the same 2 cases. In Senate, this court held in 2013, it's just going to read one sentence. Although the lost earnings award was based solely on plaintiff's testimony without supporting documentation, defendant did not challenge the testimony by using plaintiff's employment records or any other evidence. And there's a similar sentence in this court's decision in Grinnell. So in our case, it wasn't the sole evidence. There was ample documentary evidence, and there was also evidence of plaintiff's employer who said that Mr. Enriquez Rodriguez in those last few years before the accident was paid $100 or more. Mr. Enriquez Rodriguez testified that he was paid $130 a day. It's obvious from the calculation, because it works out literally to the dollar, that they credited his testimony. Unlike those two cases that I just cited, where this court accepted the plaintiff's sole testimony because it wasn't contradicted by the defendant. In this
case, couldn't you argue that it was contradicted by the defendant with respect to the co-worker's testimony as to how much time they worked together?
No, because the co-worker did not say that Mr. Enriquez Rodriguez only worked 5 days. It doesn't matter how many days the two of them worked together. There were multiple jobs. One could have been on one job site and one could have been on another.
But he said sometimes we work on Fridays. I thought that was his testimony. Sometimes we work on Fridays. We work, we normally work 3 days a week. Sometimes we also work on Friday.
No, Your Honor. He said sometimes we even work 5 days a week. But he
on a Friday.
But he was talking about when the two of them worked together. Those questions were all about the two of them working together, and there was also testimony.
Counsel, if I may, but why wouldn't the tax returns be dispositive?
Because of the two cases that we cited, that when the plaintiff testifies as to his lost earnings, and there was an opportunity, as there was in this case, for the defendant to oppose that testimony, and they didn't do it, then it can hardly be said that it was essentially irrational, which is the applicable standard.
But the tax returns are the reported earnings by the plaintiff himself, right?
Based upon the information that was given to him by his employer in the case. They were a defendant in the case. They had the opportunity to introduce evidence. In fact, the principal of that company, in fact, testified. He had ample opportunity to testify that Mr. Enriquez Rodriguez's testimony about earning $130 a day was incorrect. Not only didn't he do that, he essentially corroborated it by saying he paid him $100 a day or more. What apparently happened is he gave him a 1099, which was marked into evidence, which was another item that was introduced at trial, that reflected a lower earning. That plaintiff's employer did that shouldn't be down to the detriment of the plaintiff if he was given a document that didn't comport with what he was actually paid. What the same employer testified to, the same person who gave him the 1099, said that essentially said that 1099 was low because I paid Mr. Enriquez Rodriguez $100 a day or more during many years leading up to the date of the accident.
And he was paid in cash. He also testified that he was paid the $130 or the $100 in cash.
I think he said generally, mostly in cash. So with all of that evidence, it's hardly irrational for the jury to faced with a trial where the employer was there, where he was represented at trial, where the principal testified at trial and didn't contradict the testimony of the plaintiff. It's hardly irrational for the jury to credit that testimony. And based upon this court's rulings in Sinit and Grinnell, this court is authorized, as the trial court did, to sustain the jury's award, even if it were based solely on Mr. Enriquez Rodriguez's testimony, which in this case it wasn't. It was corroborated not only by his testimony, but by the testimony of his employer.
Thank you very much, counsel. You're out of time. Thank you. Next matter is Ambase Corp versus 111 West 57.
Thank you, Your Honor. May it please the court. Haley Proctor on behalf of the plaintiff's appellants. There are two key facts from which this court can and indeed must draw the favorable inference that the contributions from third parties upon which sponsor relied to meet the capital calls took a form prohibited by section 2.8A2 of the joint venture agreement. First.
Ma'am, counsel, where in the, excuse me, this is Justice Shulman, where in the pleading do you say that the contribution, the capital contribution came from third parties which had an equity interest that would have warranted a change in the investor status pursuant to subdivision 3 of the very section you're citing to? I mean, was there anything in the pleading that actually spells out the violation of the joint venture agreement?
Your Honor, the answer is yes. We do allege in the pleading that that there was a violation of the joint venture agreement. We do not allege that they took the form of that they received an equity interest. We do not know.
And does the subdivision 1 of that section allow, or one can reasonably derive from that section, that the initial capital contribution can come from loans, correct?
That's correct, but loans that are not secured by a direct or indirect interest.
I understand that, so that if one can get a loan without an equity interest, and one can get a loan, and we know that definitionally a lender is not necessarily an investor, so that based on the pleadings, again, I restate my position, where in your pleadings do you say an alleged fact, if you will, that the sponsor got capital contribution that allowed for an equity interest that would violate subdivision 2, and of course, by failing to identify them as investors, violate subdivision 3?
Yes, Your Honor, and let me clarify that when I say we don't allege that it took the form of an equity interest, we adequately allege that these third parties are facts from which this court can infer that the third parties received some sort of an interest in the property, direct or indirect.
But that sounds totally speculative. Based on what?
Based on 2 facts, Your Honor. The first is that sponsor hid the capital contributions from third parties.
Well, if loans are permissible, which I think you're conceding, then what's there to hide?
Your Honor, we are not conceding that loans are permissible. If the
okay, so let's go back to that. Why aren't loans permissible under Section 2.8? If don't we have to read the both provisions together?
Yes, Your Honor, we do believe that the court should read both provisions together, and we believe that subsection 1, which Justice Shulman points to, provides evidence that the parties were concerned about financing that even took the form of a loan if that loan was secured by a direct or indirect interest in the property. So if it was formally a loan, but what secured that loan was a direct or indirect interest in the property, that would qualify as a capital contribution. And we do allege facts from which the court can draw and must draw the favorable inference that the contributions took that form. And there are 2 facts. The first is the secrecy, and this court has held that an allegation of cover-up suffices to support an inference of breach. And then the second fact is that the third parties gave their money directly to Control, which was a special purpose entity whose only interest was its stake in, whose only asset was its interest in the project. So it is more than reasonable to infer these third parties didn't give the money as a gift. They gave it in exchange for something. And it is more than reasonable to infer that they were given an interest in the project or the property.
But you need an allegation with respect to that, no?
Your Honor, we allege the ultimate fact of breach. We allege that these third-party contributions breached Section 2.8A2. And then we allege specific circumstantial facts from which the court can and must draw this favorable inference. And these allegations are more robust than this court has held to support a breach of contract claim. For example,
but your allegation is that defendants finance sponsors additional capital and shortfall contributions, period. I mean, how is that, even if we viewed it liberally, how is that, how do we read that to say that financed each contribution through an equity arrangement prescribed by Section 2.8?
Well, we go on to specifically allege that those third-party contributions breached Section 2.8, and that's in paragraph 164 of the complaint, and again in paragraph 205B of the complaint. So grammatically, did we say the third parties contributed capital contributions? No, but we allege that the contributions took a form that breached Section 2.8A2, and that is a capital contribution. And
would you not also have to disclose the third-party funding, the third-party sources of funding?
That's correct, Your Honor. Separately, we allege a breach of Section 2.8A3, and the key term there is investor. And the term investor is naturally understood to encompass both, investment is naturally understood to encompass both equity and debt investments. And the
let's assume you're right about that. What are the damages? What damages flow from breach of subsection 3?
Numerous damages from subsection 3. The reason that the plaintiff, sorry, that was my timer.
Yes, and it was correct because you are out of time. Very good. Thank you very much. We need you for all of the oral arguments to keep time. Thank you. I appreciate it. You can complete your response. Go ahead.
Okay, yes, ma'am. Thank you very much. So the answer to your question is that investment had valuable contract rights, for example, a put right, and it relied on the belief that was mistaken that the sponsors who were controlling the development and construction remained fully invested in the project. Investment also invested millions of additional dollars in reliance on that understanding. And so there are clearly damages in this instance.
Thank you. You do have 2 minutes on rebuttal. Yes. Respondent?
May it please the court, my name is Mark Walfish and I represent respondents. I want to spend the first top part of my time talking about the insufficiency of the claim, and time permitting, I will address the jurisdictional issue. With respect to the claim, as you know, the 57-page complaint before you says nothing, absolutely nothing, about having used capital contributions.
Well, counsel asked that we should draw an inference based on the secrecy under which you're acting, that in fact it was a capital contribution, equity contribution.
There was no secrecy. What they were asking us essentially about were things that weren't proscribed by the agreement, and therefore naturally we didn't have to give them a response about things that weren't proscribed by the agreement. There were no secrecy. We don't have to disclose things that don't violate the agreement, and that's what we're talking about. What they basically are saying is that the conduct they're complaining about might or might not constitute a violation. They say, and again, the complaint talks about third-party financing. They say it might embrace the use of capital contributions in addition to loans. According to them, because they allege conduct that might constitute a violation and that might not, they should be permitted to pursue that claim.
Well, how would they know? How would they know without conducting discovery?
Well,
whether or not there was a capital contribution.
Judge, respectfully, the way the system works normally under a jurisprudential system is you don't walk in and say, I don't know what occurred, and so let me take discovery. So let me see if I can find a claim. Before you get discovery, you have first to have to plead a claim that is sufficient to survive a motion to dismiss. Let me give you an example, Judge. If there's a contractual exculpation clause pursuant to which I'm liable only for gross negligence, a complaint's allegation that I was negligent with no supporting facts doesn't state a claim. The naked allegation that I was negligent, even though some negligence constitutes gross negligence, doesn't state a claim because there's no allegations that what I did constituted gross negligence. The point is, even though something broad, which is not forbidden, may embrace something narrower that is forbidden, a conclusory statement that I engaged in conduct which might or might not have constituted a violation with no supporting facts, none, fails to state a claim. And their own brief, and I'm quoting from page 10 of their reply, says, quote, true, depending on one's definition of capital contribution, it is more or less conceivable that the third-party financing on which sponsor relied complied with section 2.8a. Those are their words, not mine. What they are saying is maybe the sponsor did nothing wrong. Maybe they don't have a breach of contract claim after all. Respectfully, if they can't come in and affirmatively state that the agreement was violated and how it was violated, then they simply don't state a claim.
And section 3 requires, counsel, you to disclose changes to direct and indirect investors. Was this provision breached by you?
The answer is absolutely not. There are no investors. Loans don't constitute an investment. If a bank makes a loan to me, they're not an investor in my company. What they're doing is playing with words. And the agreement was very, very, very specific, drawing the distinction between loans and on the one hand, and capital contributions on the other, and they knew how to express themselves. As you said before, section 28A2 on its face doesn't prohibit loans. By contrast, we have 208, which specifically speaks of loans. Additionally, and I don't want to bore you, section 2.13 on page 414 of the record provides that in the event of breach of other provisions, amount shall not constitute capital contributions or loans to the company. Two different things entirely. Again, in section 8.6a on page 44 of the record, it says neither sponsor nor its affiliates shall be required to lend any funds to the company, and sponsors shall only be liable to make payment of sponsors' capital contributions.
So, counsel, then how would they know whether it was a loan or a capital contribution? The only way they would know that is because if it were in fact a capital contribution, you would have disclosed it to them, and because you did not disclose it to them, then they have to therefore assume that it was a loan?
The answer, Justice Weber, is you have to come in with some evidence of a violation. They've come forward with no facts whatsoever. That's like saying, suppose someone claims that I'm negligent, but comes up with no facts at all. Are they entitled to discovery to ascertain whether they can find a basis for saying I was negligent? I don't think so. And I want to emphasize, we are not talking about a heightened pleading standard or they're giving us notice of the claim. Rather, this is the central allegation of this portion of the complaint. And when the central allegation is simply that on information and belief, I believe you may have violated the agreement, and I have no facts whatsoever that are set forth as the basis for that conclusion, the allegation is merely conclusory and doesn't state a claim. That's the problem with that position.
Any other questions? Thank you very much.
Thank you.
Mr. Proctor, you have, I believe you have 2 minutes on rebuttal. So don't you need something a little bit more? Again, we're back to the pleadings, and I know we discussed this previously, but again, as your adversary says, how do we know that this was a capital contribution and not a loan? And don't you have to give us a little bit more showing that it was in fact, don't you have to plead a little bit more showing that it was in fact a capital contribution and not a loan?
Your Honor, we do not. And it is clear from respondent's argument and from their brief that what they are trying to impose here is a fact pleading standard in which we plead facts that rule out all unfavorable inferences. That is not our burden. We do not have details, as my friend acknowledged, we do not have the details of this financing to be able to plead those facts for the court. Instead, we are asking the court to draw favorable inferences from the circumstantial evidence that gave rise to a good faith belief that these contributions did in fact violate section 2.8A2. Now, we spoke a little bit about secrecy, but I'd like to emphasize that that is not the only fact here. The other fact is that Control is a special purpose entity. It had nothing to offer these third parties apart from its interest in the project. And an important point here is that a premise of respondent's argument is that capital contributions is a term that's used in contradistinction to loans, but it is not. Capital contributions, as it is used in the joint venture agreement, can include loans. And yes, it is true that the agreement elsewhere uses the term loan, but the agreement also elsewhere uses the word equity interest. Respondents would have the court construe capital contribution as an exchange for an equity interest. But the joint venture agreement simply doesn't support that. To the contrary, A1 shows that the parties were concerned about any sort of a contribution that gave the contributor a stake in the project. And A3 also supports that construction. And as I have said, although we cannot allege to the court details about the form and the terms of this financing, we do have a good faith basis to believe that it took a form that was prohibited.
Thank you very much. Thank you both.
Thank you.
Next matter is Bny Mellon versus Feldman.
Yes, good afternoon. My name is Paul Weinstein, and I represent Bny Mellon, the appellant. This case is a contested accounting proceeding, and this is an appeal from a finding of liability on a few of the objections that were made by two objectants, Marshall and Gary Feldman. And what the core facts are is
Counsel, why don't you address the foreclosure sale? How were your client's actions reasonable? in light of the delay in informing the objectants with respect to the foreclosure?
Your Honor, I don't think there was a delay, and I think that Bny Mellon.
Weeks didn't go by?
Excuse me?
Weeks did not go by?
What the facts at trial showed were that there was a fax. This is how old this case is. There was a fax that was sent in late May. It was not received by Bny Mellon. When notice of the foreclosure was given to the tenant called Bny Mellon.
And that was in April, correct? April?
No, that was in May. That was in late May. I believe it was May 24th.
Okay.
And what Joseph Marrero, the Bny Mellon employee, did, he said, what is this about? And he was told, I'll send you the papers by the tenant. He didn't receive the papers. He followed up in early June. He received the papers on June 6th, and he reacted immediately. He called everyone involved, including the respondents here. And he fully briefed them on what occurred, and they made the determination themselves.
But at this point, how much time was left before the foreclosure was scheduled for sale?
Approximately 6 days.
So that sounds like it's a very truncated period for parties to act.
It is 6 days. You know, I'd like to emphasize that Marshall Feldman in particular was fully knowledgeable about this building and about all the specifics of the rental payments. He interacted with his cousin whose interest was being foreclosed. There was evidence presented at the trial of spreadsheets prior to the foreclosure action, prepared by Marshall Feldman himself, where he charts out what the rent is going to be until 2006. In fact, his handwritten notes were offered into evidence at trial. It's Exhibit 88, and it's from 11 months before the foreclosure. They're his own handwriting. And what the handwriting shows is the rent for each year until 2006. And it also has the value of the property. He was completely knowledgeable.
I want to go back to the issue of the foreclosure sale and the notice or lack of notice.
Yes.
Because as you know, the bank is held to a higher standard than a regular person, right? So here you have May 22nd, Fresenius tells Mr. Marrero of the bank that it's received a notice of a judicial sale, and nothing really happens for 2 weeks. Nothing really happens for 2 weeks. The notice is supposed to be faxed to him. He doesn't receive it. He asks for a copy again on June 5th. How does that show that the bank was acting in its capacity as a prudent investor of discretion and intelligence with the requisite special investment skills? I don't understand how you hear, hey, the property's going to be sold, and you do nothing.
Well, Your Honor, Bny Mellon was the trustee at that time for approximately 26% of the property that was in trust for a separate relative, the Chester family. The interest of the Feldmans was owned by them in a distributive share account, approximately 26%. In a very complicated structure put together in the early 1960s, another trust for which Bny Mellon was not trustee owned another approximately 12%, right? And Bny Mellon knew about all those interests. So it knew in May that—
Are you answering my question?
Yes, I am. I'm getting there.
It doesn't sound like—
And here's why I'm answering your question. Bny Mellon was aware that there could not have been a foreclosure case on the interest for which it was responsible. That's my point. So, Your Honor's question I believe, was how could Bny Mellon not have reacted when it thought that the property was going into foreclosure? My point was it knew that that was not possible for the interest for which it was responsible.
But that's really, I'm sorry, I really, at least speaking for myself personally, I can't accept that argument, because if part of the property is sold, that impacts on the portion that your client is supposed to be managing. No?
Well, I understand Your Honor's observation, but Bny Mellon's obligation was to the interests for which it was trustee and for which it was managing, that were in a distributive share account.
So you're saying Bny Mellon had no responsibility to notify Mr. Feldman as to the foreclosure?
It would, well, the testimony was that it would be best, certainly would be best practice to do so. But the Feldman's interest of 24%, a total of 33%, all right, was not affected by this foreclosure in the sense that it wasn't devalued.
I agree with my colleague. I don't understand how you can make that argument. You're splitting up the property. And I do not understand how, if you own 26%, regardless of the other 74%, that the 74% is not going to, the sale of 74% is not going to affect your 26%. That just, I don't understand that at all. But well, you can speak about that on your rebuttal.
Well, may I answer that question?
Yeah, go ahead.
The property was already split. Someone else owned it. So nothing, it was just a property,
that's that argument. I'm sorry, that's a disingenuous argument. That's family. All of a sudden you have a hostile purchaser and an investor is going to come in. What's the first thing the investor is going to do? It's going to set up a partition action. I mean, that's exactly what occurred here.
Your Honor,
right?
It was the relative who was hostile.
Okay.
That's it. That's the
but we still had, but yeah, okay. So you have time on rebuttal.
Thank you.
Good afternoon, Your Honors. My name is Jeffrey Metz. I'm with the firm of Adam Lightman Bailey PC. We represent the Feldmans in this appeal. I'm here this afternoon, Your Honors, asking you to affirm the order appealed from. I think the issue before this court is whether the court's conclusions could not be reached upon any fair interpretation of the evidence. And as the bench has found, is by the tenor of their questions, is certainly backing up exactly what the surrogate said. Now, what my adversary said is not particularly reflective in the record, because if you want to go through what happened here with the foreclosure, Merritt found out about this on 5/2. On 5/4, the tenant faxed the foreclosure notice, and it went to Bank of New York. It was ignored. Finally, because the record shows, the fax also has another one, sending you another one, Joe, and that was on 6/5. Now, what happened then? Within the bank, there's Marrero, the so-called property manager, Houghton, who was supposed to be administering this trust, who conceded that he had no real estate experience. The bank did not consult with their own counsel to find out what to do, whether the sale could be postponed or set aside. And one thing my adversary's really forgotten, is a very key factor of this case. My clients were entitled to their share in 2000. The property was not deeded over to them for 10 years. So I think, as you said, Justice Singh, it's somewhat disingenuous to argue that there was no obligation to my folks, because we owned it, but we didn't hold title to it. So we couldn't even postpone the sale, which we tried to do, and we couldn't. Now, it gets even worse, because my client, Mr. Marshall, he finds out about this on Friday at 3 o'clock on the 8th. And he had no information. He had no information to give Marshall other than you better speak to Mr. Marrero. Well, he couldn't get to speak to Mr. Marrero because of the weekend. So he didn't speak to Marrero till the 11th. That's 2 days before the sale. Now, My clients are not sophisticated foreclosure people. I mean, you have to have an appraisal. Gary Marshall testified he saw one. He did not get one. They did not have sufficient information to make a prudent decision with respect to that. Now, certainly here, this bank is held to a higher standard. They're supposed to exercise special skills. And what you've got also here in terms of just your jurisprudence of whether you affirm or not, you have to look at the conflicting witness testimony. Now here.
Can I interrupt you a second and ask you to address one specific objection, objection 28, if you don't mind, where you claim that the Feldman Trust was deprived of fair rental income from May 2006 until the present. How is that so?
Oh, well, what happened, Your Honor, when the lease was renewed, there was a bump up in the rent, even though it was problematic because it was warehouse rent and it wasn't based on warehouse plus improvements, which, by the way, happens to be a violation of the lease, another dereliction of duty.
No, I'm asking you in reference to
I'm sorry.
I'm asking you in reference to the fact that the lease said that the assignees, any assignee would be able to lease on the same terms as the original tenant. So how do you say that there was a loss of income in objection 28?
Sure. Well, the loss of income stems from three particular factors. Number one, as the circuit found, given the fact that the bank first was an absentee landlord, let the property, the property went into, they didn't pay any rent, they went into bankruptcy, it came back in a deplorable condition. That's because of their lax management led to the fact that the rental was based on warehouse space because the tenant was going to improve the space. Now, by the way, the lease also provided.
And I'm sorry, when did Mr. Metz, when did this occur? This was in the late 90s?
96, Your Honor.
Okay,
94 was the bank.
So let me just ask a question. In 1998, what happened? Didn't the surrogate find that the releases were valid for 1998?
Yes, that's correct.
So if they were valid, essentially, my recollection, the surrogate found there was no bad faith, fraud, or duress. So doesn't that put an end to the issue with respect to renewal, et cetera?
Well, that's what the bank would have you believe, but as
I'm asking, why doesn't it?
Okay, well, I'm going to try and answer you. As the surrogate found that there were three factors involved. One, key was the fact that the property had not been turned over to my clients when it should have been. That's 6 years into their being able to own this outright, and it still wasn't turned over by the bank where they were getting commissions and management fees. That's number one. Number two, the surrogate found that just the entry into the lease itself for a 25-year period, without taking into account the age of the beneficiaries, when these rights were going to vest, that in and of itself was negligent. And to make matters worse, if you look at 20.02 of the lease, the renewal provision, it says that the rent will be based on warehouse space plus existing improvements. Now, when Marrero got the appraisal, which by the way was 4.5 months too late, he told the appraiser, just base it on warehouse space, not warehouse space with the improvements. So and in addition to all the foregoing, you also have the situation where the lease provided that the improvements were supposed to cover the floor space. It's defined in the lease as 1,630 square feet. There's testimony in the record that only 66 to 75% were covered. So you can extrapolate from that they did not even have to renew the lease because the tenant was in default at the time they made the notes. So, and the last part of this, Your Honor, is that this trial was bifurcated. First to find liability and then to find damages. So I can't speak to you on damages because that has yet to occur.
Thank you, counsel. Your time's up. Mr. Weinstein, I actually said you had time on rebuttal. You don't, but I'll give you a minute if you want to respond.
Okay, thank you very much. Counsel's argument about what occurred with the property previously or what the terms of the lease are exactly the question that was not answered about the receipt and release. The receipt and release post-dated those events. So the receipt and release released those events, and the evidence in the record is overwhelming that Marshall Feldman in particular, but both objections knowingly entered into the receipts and releases.
Thank you, counsel. Thank you very much.
Okay, thank you very much.
The next matter is People v. James Smallwood.
Yes, Your Honor. May I begin? This is Emma Schriefter from the
Yes,
Office
please.
of the Appellate. Sorry?
Please. Yes, please proceed.
Thank you. Emma Schriefter from the Office of the Appellate Defender on behalf of Mr. James Smallwood. Mr. Smallwood received the maximum sentence for a low-level nonviolent offense. He has shown that he is ready to make positive decisions moving forward based on his expressions of remorse and his steps towards rehabilitation. He also has cognitive limitations, learning issues, and had a traumatic upbringing, which have affected.
Counsel,
Yes.
where does the record specify what the cognitive limitations are?
Unfortunately, defense counsel didn't place onto the record his expert report that he got completed, but this court should credit defense counsel's assessment of the report, as he stated.
Where is the severe trauma specified?
That also was not specifically specified. Mr. Schwartz, defense counsel, did say during sentencing that Mr. Smallwood had one of the most traumatic childhoods he had seen.
And
Again,
counsel,
unfortunately,
doesn't the pre-sentence isn't the pre-sentence report devoid of any indicia indicating a limitation as to any limitations or psychological diagnosis, treatment? Do we have anything other than an attorney's statement that his client or her client has problems?
No,
unfortunately. I looked everywhere, and I'm saying, where's the backup for this? And I didn't find it. So I want to know if my search was a walk in the wilderness, because that's what it felt like.
No, that's right. I believe the only notation in the pre-sentencing report is that Mr. Smallwood grew up in foster care and that he was removed from his family at an early age. But it's right, there's no record specifically of the cognitive limitations, the trauma, and the learning issues. But I do ask that this court.
Counsel, you're asking us to, I guess, accept what defense counsel believed, but this was a negotiated sentence. Didn't that go into consideration when the defendant and defense counsel negotiated the sentence?
Right, but that still doesn't warrant the maximum sentence here. And here, Mr. Smallwood.
I thought the maximum was 15. Am I mistaken about that?
No, the range here was 3.5 to 7, and that's what was imposed here.
He wasn't facing a 15-year term with 5 years of PRS?
No, you may be referring to what he had he been convicted of the charged crimes, but in terms of the crimes of conviction, the maximum is what he got, which is 3.5 to 7.
So he had never been arrested before, is that correct? He was not a predicate?
No, he was. He was sentenced.
He was a predicate. What was he a predicate for?
He had a prior assault case. But I would say that.
Was this his 4th felony conviction and his 2nd involving a weapon?
Yes, but again, in this case.
And so he had this was his 4th felony conviction. It was his 2nd involving a weapon. He had been released on parole. He violated his parole. He was released on parole a 2nd time, and he violated his parole the 2nd time. This particular case, he was in possession of a loaded firearm, which he stated he needed for protection because of his profession, which was selling drugs. And so you believe that based upon all of this, that the sentence of 3.5 to 7 was excessive?
Right,
And what sentence should have been imposed, Counselor?
I would suggest a sentence lower, or sorry, closer to the minimum here. I wouldn't suggest a
And what
specific
would that
sentence.
be? Closer to the minimum of, so what? Is that, what, 2 to 4? What is that?
Yes, that's the minimum here. And I would say that the criminal record does not warrant the excessive sentence here because of the steps he took during his incarceration to learn the tools.
Was this the incarceration on the 3rd felony conviction? The incarceration on the 2 parole violations? Which incarceration are we referring to?
The incarceration leading up to his plea in this case. And during that time, he took anger management courses, vocational training, career readiness
Was anger
classes.
management an issue for selling drugs and being in possession of a weapon while selling drugs? Was there an anger management issue? Was he angry at the drug buyers? I'm sorry, you have time on rebuttal. Yes, people?
May it please the court, my name is Shane Magnetti. I represent the respondent. Your Honor's defendant's sentence is eminently fair. It is completely justified by his extensive criminal history. As Your Honor just noted, he has, as of this conviction, 4 prior felonies, 1 involving criminal possession of a weapon and 1 involving assault 2nd degree. Now, this indicates that he has a history of violence and of weapon use, and all of his parole revocations indicate that despite his prior legal sanctions, he has yet to be rehabilitated or deterred.
So your adversary stated that he received the maximum for a low-level nonviolent offense.
Yes, and 3.5 to 7 is the maximum for the crime that he did plead guilty to.
Because he pled guilty on the drugs, he didn't plead guilty to the gun, right?
No, Your Honor, he pled guilty to criminal possession of a weapon in the 3rd degree.
Oh,
and he was allowed, yes, and he was allowed to plead guilty to one of the non-violent counts in the indictment, as opposed to
So what was he
pleading
facing?
guilty.
What was he facing? 15 years?
He was facing 7.5 to 15 years determinate with 5 years post-release supervision if convicted of one of the 2 C violent felonies on which he was indicted. Nevertheless, he was able to negotiate this lenient plea deal to an indeterminate sentence of 3.5 to 7. And it's important to note that several of defense counsel's purported mitigating factors, as Your Honor noted previously, were already considered by the people and by the court in negotiations and are reflected in his sentence. At sentencing, the defendant's attorney noted that he expressed his concerns about the defendant's background to the people and went so far as to thank them for extending the offer that they did in this case. That indicates that the people were aware of and considered his cognitive issues and his childhood. So for those reasons, the defendant has not demonstrated any circumstances that would render his sentence excessive. Therefore, the court should not disturb it. Regarding his waiver of his right to appeal, unless Your Honors have any questions about that, I will rely on my brief for that and ask that this court affirm.
Thank you.
Thank you, Your Honors.
Counselor, were you arguing at all that that there are any issues concerning his ability to understand the waiver?
No, Your Honor. He never stated on the record, he was never even asked whether he understood the waiver. The court asked, did the attorney review the waiver and did you sign it? But there's no on the record confirmation that Mr. Smallwood understood the terms, and we know that that's required. Do you voluntarily
waive your right to appeal in return for the plea and sentence promise? Answer, yes. You're saying yes. That's insufficient?
Yes, he needed to have said specifically, there should have been a question, do you understand the terms? And Mr. Smallwood had to confirm that he did. And additionally, the colloquy was so imprecise and cursory that there was no explanation that this waiver would bar review of the severity of the sentence. And the court also didn't explain that these rights were separate and distinct from the trial rights.
Counsel, if I may, didn't the defendant file a notice of appeal the very next day after sentencing? And doesn't that show that he actually did understand what his appeal rights were?
Well, I would say that, to begin, that would have been his attorney that filed it, but also there still needs to be the on-the-record confirmation that Mr. Smallwood understood the terms. Even with the filing of the notice of appeal, there still needs to be the confirmation that he knows what that waiver meant.
Thank you very much.
Thank you.
The next matter for argument is Fritz versus Sadi versus 315 East 68th Street. Respondent.
Thank you, Your Honors. This is Meredith Cavallaro for the respondent. The Supreme Court dismissed plaintiff's complaint because the claims asserted have already been litigated. There was a grievance made and the union brought an arbitration on his behalf, which, as we see from the complaint, the plaintiff participated in. During the grievance hearing, the arbitrator addressed and made conclusions about the very issues that the plaintiff now brings before.
Counselor, this is Judge Singh. So there's an arbitration dealing with compensation, correct?
Correct.
Why didn't your client raise the issues with respect to the extra compensation that he was entitled to at the hearing?
I represent the respondent, Your Honor.
I'm sorry. Do I have the wrong? I have the parties reversed.
My understanding is the appellant did not request time for our.
Yes, and so, Counselor, you're asking us to affirm the motion court's decision.
I am, Your Honor.
Finding that there was res judicata.
Correct. Yes.
Any questions by anyone? No? Anything further, Counsel?
No, thank you.
Thank you so much. Take care. Have a good day. Fritz versus JLG Industries.
May it please the court, my name is Jackie Silver and I represent defendant appellant JLG Industries in this matter. While we have many arguments in our brief, I just want to touch on one thing today. Summary judgment for JLG was decided on erroneous facts that were not contained in the record, and thus it should go back to the lower court for consideration. There were two errors that the trial court made. The first one was that the trial court stated in its decision that JLG inspected the lift 3 months prior to the accident, and then we certified the machine as safe and operable. This is simply not true. That never happened. United Rentals was in fact the one that inspected the lift 3 months prior to the accident.
So what did JLG do?
We received a call about it, but we did not inspect it. In fact, from the time of manufacture and sale in 2007 to the date of the accident in 2010, JLG never inspected, had any control, never operated, or had any possession of the lift. So put simply, the trial court based the decision on.
To ask you an ABC question, are there any manufacturing defect issues raised here, or do they all have to do with design?
They all have to do with design. Fritz and TBTA's experts said nothing about manufacturing defect. There's no question of fact on this claim. So it does have to do with design defect, but that's my second point of the error that the trial court made. And in their decision, they stated that the wire ropes were not visible to the user and that they are only detected through the cable service indicator light. And this is the claim that goes to design defect, that the wire ropes weren't visible. And again, this is simply not true either.
But isn't the claim more nuanced than that? Is that in order to really do a full inspection, you have to open up the device to look at the wire? Isn't that really what the claim is? And that's the design defect?
The design defect is that you can't fully view the entire wire rope. However,
opening up the casing or whatever it is to be able to view the wire.
That's true, but you don't need to open the entire thing. There's two access points on the lift. There's one at the base of the boom and one in the boom. And if you open those, the wire ropes and the sheaves are within inches of those access points. And there you can look for any damage, if the wire ropes are torn, if they're off the sheaves. So it's not necessary, and that's in fact a red herring in this case, that you don't need to see the full length of the wire ropes. You can see just what you need to see through the access points. And this is what the lower court stated in their decision that is factually wrong. And I would submit that there's photos in the record.
Were there experts on the other side that stated that you needed to open it up? So did that not create an issue of fact as to whether you did or did not need to open it up? So basis for, and then form the basis for the denial of the motion for summary judgment?
They believe that you need to open it up, and while we we suggest that the boom is taken apart every 7 years for inspection. If you have frequent inspections and you look through these access points regularly, which we require through our manuals, then you don't need to do the tear down to see the entire wire ropes. You would see it just through the access point.
But my question is, don't we have an issue of fact?
No, Your Honor. I believe that you don't need to see the entire wire rope.
I guess what you're asking us to do is to weigh the relative opinions of the experts and say that your expert's opinion makes more sense to us than the opinion of the other side. Isn't that really function for trial?
So, well, this can be viewed as a battle of the experts. It's just a matter of fact, though, that one of the access points was within inches of where the wire came off the sheave, and you can see that. And that's we designed this boom lift with the intention so you can see that, and that's what our experts state, that you can adequately see what you need to see through the access points. And not only can you see them, but we have testing, and in our manuals, there's considerable detail of how to test the tension of these wire ropes without even looking at them. And that's the point that the court got wrong, is that the only way to know the tension is through the cable service indicator light, and that's not true. So I'll conclude with the lower court reached its conclusion on facts not in existence, and we would just ask this court to reverse the lower court's decision as it relates to JLG.
Thank you.
Good afternoon, Your Honors, and may it please the court. My name is Jamie Regan on behalf of United Rentals. United Rentals respectfully submits that the trial court erred in denying its motion for summary judgment as well. I would give the court two primary arguments. The first being that United Rentals, as an out-of-possession lessor, did fulfill its limited duties to deliver and maintain this lift in good working order. The second being that, notwithstanding any of that, there's simply no evidence.
What I just heard from from the manufacturer was that there were very simple ways to be able to inspect the steel wires. Did your client, in fact, undertake that, inspect them, do all the proper tension testing, et cetera, that it's in the manual?
Absolutely, Your Honor. In fact, the record is replete with evidence both from deposition testimony of two United Rentals mechanics that 6 weeks and not 3 months prior to the accident, which was an erroneous factual finding by the court. A mere 6 weeks beforehand, our mechanic went out and did a quarterly inspection in which they took the boom covers off that counsel referenced. They shined a flashlight up into the boom to see further up into there with regard to the cables. They tugged at them, and critically, they did functions testing from ground control, which actually required operation of the boom, retraction, extension, telescoping, which would by definition have revealed any cable breakage. So a mere 6 weeks beforehand was the last time that United Rentals had any contact with this machine. It was the last time United Rentals was required to have any contact with this machine because it never received a service call in the interim. And at that point, it properly certified that the lift was in good working order. And that fact is really borne out by the fact that over the next 6 weeks, this machine was operated for a total of 60 hours without incident. Nobody ever called to document any complaints or maintenance issues. I'll touch briefly on the point of proximate cause, which we explored at length in our briefs. Simply put, the plaintiffs in this case did not perform pre-start functions testing, whereby the manufacturer actually requires them prior to getting into the basket of the lift operate the boom, send it up, retract it back, telescope it in and out in order to detect the very issue that could have prevented this accident. And that really speaks to the failure of the TBTA and the general contractor on site, Conti, to properly train plaintiffs in the safe and effective use of this equipment.
And so, Counsel, this is in the record. The record states that this was not performed by plaintiffs.
Yes, in fact, it's undisputed. Plaintiff Fritz admitted it at deposition. Plaintiff O'Keefe said that he didn't do anything. He relied on Plaintiff Fritz to perform everything. Plaintiff Fritz did do a cursory visual inspection, but he didn't operate the lift from ground control, which is a preventative measure that's in place to detect exactly what happened. So not only does this speak to failure to train, but it also speaks to the issue of, to the extent that TBTA will argue that Conti provided training, it just simply speaks to the issue of failure to properly supervise plaintiffs in actually adhering.
Counsel, are you arguing that the plaintiffs are the sole proximate cause of the accident?
No, Your Honor. United Rentals is not a labor law defendant, so we don't need to prove sole proximate cause. I leave that to plaintiffs and TBTA to hash out. I'll just say that as superseding causes, any negligence on the part of United that's alleged would clearly have been broken. The causal chain would have been broken. And
isn't that an issue for trial? I mean, it sounds like a good argument, but why isn't that a issue for trial?
Because there's clear First Department case law that indicates that an end user's disregard or failure to follow product warnings is as a matter of law.
But it wasn't complete here, as you're acknowledging. One of the plaintiffs did do a visual inspection.
Yes, Your Honor, but they did not do the pre-start functions testing that was also required, and that's undisputed. And I would just note that the trial court erred in finding that it was that Plaintiff Fritz conducted a proper inspection, because while we agreed that Plaintiff Fritz did do some sort of visual inspection, he certainly did not perform any of the functions testing, which would have been critical to detecting any alleged problems with the boom lift prior to the accident on that morning.
I thought JLG said that a visual inspection was sufficient.
JLG did not state that a visual inspection was sufficient. The operator's manual notes that the machine should not be used or operated prior to conducting testing from ground control. In other words, prior to using the control box and panel before getting into the lift. And there are actually warning decals, which are part of the record, that were affixed directly to the lift that in big, bold, capital letters say, do not use this until certifying or testing the boom and ensuring that all components are working correctly.
Thank you very much, Counselor.
Thank you.
TBTA?
Thank you, Your Honor. May it please the court, Adrian Yaron for MTA and TBTA. The ropes that broke are approximately 35 feet long. The court could see from the photographs in the record, they broke somewhere in the middle. The metallurgist, Mr. Vecchio, who examined these ropes after the accident, said they broke because there were many wires in these ropes that were broken, frayed, rusted, kinked. Okay. JLG's own manual says these ropes need to be inspected every 3 months for exactly those deficiencies, breaks in the wires, kinks, rust, frays, and that after inspection, they should be lubricated. Every one of United's 3 technicians who testified admitted they never did that. They never did that because they couldn't see or access more than a foot or two of these cables from either end of the boom through these panels that you're supposed to open. And our own crane expert, Mr. Kohler, tried the flashlight technique that JLG insists is what should be done. And he also couldn't see more than a foot or two of these ropes from either end of the boom. Okay, so the area where these ropes broke was never inspected or lubricated in the entire 3 years that this crane was in existence. JLG, there were alternate designs available. Our expert, Mr. Hagan, discussed alternate designs of other booms that were available at the time, where you could inspect the ropes better. He also noted that JLG could have included a borescope with the boom to inspect them. He also noted that the cable indicator light that JLG talks so much about wasn't actually attached to these ropes, which were the retractor ropes. The cable indicator light was attached to the extender ropes, which didn't break. So it's irrelevant what the cable indicator light did or didn't do. The metallurgist also was very clear, Mr. Vecchio, in his affidavit, that these ropes broke because of an extended period that this wear and tear built up without being noticed or corrected. Now, United simply didn't inspect them. The testimony is clear. All three of United's witnesses said they see these ropes. They did the best they could, but they couldn't see it inside the boom, and they didn't inspect it.
Could you address the issue in terms of the failure of the plaintiffs to test the equipment prior to its usage, and therefore United's argument that there was a lack of supervision or training on the part of TBTA?
Right. First of all, it's an entirely a red herring. As United's own attorney just said, this machine was used for more than 60 hours in between when United last inspected it and when the ropes broke. Okay, so saying that possibly running this ground control operation for less than a minute would have necessarily broke the ropes before this accident. This was a sudden catastrophic accident where these ropes just snapped. Whether they would have snapped in this ground control is just speculative. And even so, it doesn't excuse the fact that United rented a machine that was never inspected as the manual said it should have been. And JLG's own witness, by the way, Mr. Forgas, also testified he knew that you couldn't inspect these entire ropes. So the argument against JLG is not only that they designed it properly, but failure to warn. JLG could have prevented this accident simply by putting in their manual to disassemble this boom once a year or once every 3 months instead of once every 7 years, because it knew you couldn't inspect those ropes without disassembling the boom. It was as easy as that, but instead they didn't. They knew you couldn't inspect ropes, and they sent it into the stream of commerce anyway. And United knew they couldn't inspect these ropes, but they rented it to Conti anyway. And by the way, as far as TBT is the arguments made against TBTA, this machine was rented by Conti. The plaintiffs were employed by Conti. Conti is a non-party to this action. Okay, TBTA never instructed these plaintiffs, never inspected this machine, didn't bring this machine onto the site. The law is clear. This court has held many times that an owner or a construction manager that doesn't directly control or direct the specific action which causes the injury cannot be held liable for negligence.
Thank you very much, Counsel, you're out of time. Thank you. Counsel for Ortiz. I'm sorry, Counsel for Fritz.
Good afternoon. May it please the court, my name is Howard Sanders, and I am the attorney for plaintiff respondent Carl Fritz. I submit to you that the trial court's decision should be affirmed in its entirety. And I'll speak first to appellants TBTA and MTA, which has not been brought up so far today. Its reply brief, and first pointing to the last paragraph of that brief, which in its conclusion, TBTA and MTA state they no longer seek relief from this court to disturb the ruling of the trial court granting summary judgment to both of the plaintiff respondents herein. TBTA and the MTA specifically state that the only relief now being sought by these defendant appellants is, quote, that this court modify the decision of the trial court solely to the extent of granting summary judgment to TBTA over and against JLG and United Rentals on its common law indemnity and on contribution claims. As such, defendant appellants TBTA and MTA have effectively withdrawn their appeal of the decision of the trial court granting summary judgment under Labor Law Section 240 sub 1 to the plaintiff respondents. Speaking now to JLG, I would just iterate that it's abundantly clear that the conflicting affidavits of several experts have raised tribal issues of fact. I won't repeat again what
Counselor, tribal issues of fact as to design defects, correct?
As to design defects.
What
yes.
about manufacturing?
No.
Are no claims with respect to that?
No, I have no claims anymore in regard to that. Okay. And in terms of United Rentals, they claim that the negligent actions of the plaintiffs approximately caused the subject incident. First of all, the plaintiffs were trained and instructed and acted through that training and instruction precisely. That's exactly what they did on the day the incident occurred. They carried out their training and inspection of the lift exactly as they were trained to do. Nothing more was required of them.
Well, was their training, was their inspection consistent with what was required by the manual and the various decals on the machine?
I have no idea. I have no idea, Your Honor. And the decals wouldn't matter because they were illegible. As you can see, they were scratched up. And it's not their job to go beyond what their training and instruction was. In fact, Carl Redmond, who is the senior project manager for TBTA, concluded that the incident was, quote, equipment related, end quote, and not, quote, worker related. Further, United Rental, as does JLG, also engaged in pure speculation, when they both contend that had plaintiff Carl Fritz tested the telescope function, specifically the telescope function, which is the one that failed of the lift, the damaged retract ropes, which is the one that did fail, would have been revealed. However, they do not consider first that the plaintiffs had ridden the boom lift for 4 minutes before the incident occurred without any problems therein, and that any pretest telescoping from the ground would not have taken into consideration the combined weight of the men and the equipment they brought with them. So whatever the manual says, Your Honors, it really wouldn't matter in this case because that would not have been the actual functioning of the lift as it occurred with the men and the equipment in it, which had been functioning properly for 4 minutes before the incident occurred.
Thank you. Counsel for O'Keefe, you have 1 minute.
Very briefly, Your Honor, Mr. Saunders eloquently expressed the plaintiff's position in this case. Plaintiff O'Keefe only sued the owner, the TBTA in this case. The trial court granted summary judgment based upon a clear violation of Section 240, subsection 1 of the labor law of the state of New York. TBTA being the owner, they're absolutely liable. Therefore, we respectfully request, Your Honor, that the decision of the Supreme Court be affirmed with respect to O'Keefe versus the TBTA in all respects.
Thank you. JLG, anything further?
Yeah, just to go back to design defect and battle of the experts per se. This can't be a battle of the experts based on faulty facts that the trial court got wrong. I mean, everyone's entitled to their own opinion, but not the facts. You can clearly see through photos that TBTA submitted in their own brief that you can, through one of the access points, you can see exactly where the wire broke. You can see the sheaves that they're damaged. I mean, it's on record, page 2257. You can see it with your own eyes that if this was able to be viewed after the accident, it could have been viewed before.
Well, but what about, I'm sorry, but what about counsel's point that the boom lift was in operation for 4 minutes?
Your Honor, the plaintiff didn't, as JLG instructs, we require a visual walk-around inspection and a function test every single time before the boom lift is operated. It's undisputed that Fritz didn't perform this. Had he done this, which part of the function test is to extend and retract the boom before operating it, that would have revealed audible sounds, and he should have known that there was operational issues with the boom and not to use it. but he did not conduct that.
So is that not, again, speculation? That he would have heard such sounds, or that such sounds would have been audible?
Well, had he been properly trained, he would have known that. So that goes back to his lack of...
Doesn't that assume that the wire was frayed at the time of the inspection, whatever the inspection was, as opposed to 4 minutes into the operation?
Yes, there's no dispute that this wire...
As my colleague is saying.
There's no dispute that this wire was damaged prior to the incident. And in fact, I think all parties agree on that this damage occurred over a period of time. But had Plaintiff Fritz performed the function test as he was supposed to, it should have warned him at that time by extending and retracting, which he didn't do prior to the accident occurring. So had he done that, it would have revealed audible sounds that there was an operational issue.
Thank you very much. United Rentals, anything further?
Yes, Your Honor, I'd just like to speak briefly to the point of the fact that it was operated for 4 minutes prior to the accident. To the extent that counsel calls that a red herring, I'll just say that if he had performed pre-start functions testing and did not, in fact, hear the audible noises or to see any other indication that the boom wasn't operating properly, then by definition, United Rentals mechanics 6 weeks prior wouldn't have detected any issue with the breakage because it clearly wasn't detectable or severe enough at that point that it could be detected.
Counsel, everyone's talking about audible noises. So is there anything in the record that indicates that the operation of the boom emitted any kind of noise, a quiet noise, a loud noise, that all of a sudden would change if there was a problem?
Your Honor, I don't believe that even when the accident happened, such noises were necessarily revealed.
Right,
but
so isn't this all speculation about audible noise? I don't know where you're getting that from. So
well,
enlighten me.
Your Honor, here's what I'll say with regard to noise. It's not just noise, it's telescoping the boom in and out to make sure that it extends and retracts and telescopes properly and doesn't suddenly retract, indicating some breakage. And
right, that part's easy. That part's easy. But
sure.
You're all saying, or several of you are saying, that if the pre-inspection had been done, they would have heard an audible noise that would have prevented this. And I'm saying, where are you getting this from?
Your Honor, that's actually not United Rentals' position. I think that our position is, in general, it would have revealed some evidence of cable breakage to the extent that the cables were broken prior to the plaintiffs getting into the lift on the morning of the accident, and to the extent that they were not, they also were not broken 6 weeks prior, which was United Rentals' last opportunity and duty to inspect. So for those reasons, and if I could just speak to one of the points raised by the TBTA's counsel.
Unfortunately, you're out of time, but thank you. TBTA?
Thank you.
Anything
Yes,
further?
thank you, Your Honor. Yes, first, Justice Gonzalez, you're absolutely correct. There is nothing whatsoever in the record about being able to hear any audible noises in this check. That's just a hypothetical thrown out by counsel. As far as checking if they were broken that morning, I think it's pretty apparent from the testimony that they weren't broken that morning. They weren't broken for 4 minutes when the plaintiffs first started using the lift, and they broke suddenly. The testimony and all of the expert evidence is that what they were for quite some time before they broke is worn and frayed and rusted. And that existed probably for a very lengthy period of time, according to all of the experts, more than 6 weeks, probably more than 3 months or even 6 months, and during which multiple so-called inspections by United happened. The question here, and for that matter, the pre-inspected test would not cut off liability for the fact this thing was never really inspected and never really lubricated, as JLG's manual says, because it couldn't be, because it wasn't designed to do so by JLG. And the manual designed by JLG, whose testimony admitted they couldn't inspect it, should have made that manual say that the disassembly should have been done more often, so the inspection could have been done. And
thank you very much. Your time is up.
I think you're correct that there's many issues of fact here.
Thank you, counsel.
Thank you very much, Your Honor.
Counsel for Fritz, anything further? You're muted.
Sorry about that.
That was your 2 minutes.
Your Honor, thank you. Sorry, I have nothing
Go
further.
ahead.
I have nothing further, Your Honor. Thank you.
Oh, that's great. Thank you so much. Thank you all very much. Take care. The next matter for argument is People versus Waldine Elliott.
Good afternoon, Your Honors. Harold Ferguson for Appellant Waldine Elliott. Before I begin,
Ferguson, I haven't seen you in such a long time.
Yes, and actually I was going to start with, I wanted to congratulate Justices Gonzalez and Schulman on their well-deserved promotion. I appeared before them for years in the appellate term, and I'm thrilled to see you guys again.
Has it been that long since you've been here? What's going on?
As to this case, this is a sad and tragic case, and it seems like it's one of the themes of this court today. It's a battle of experts.
Yeah, I was just to say that that's what it appears to be. It's a battle of the psychiatrists in terms of whether, as to the insanity defense, whether at the time the defendant was or was not legally insane, whether he did or did not understand right from wrong.
That's exactly correct, Your Honor. And I think the most telling thing as to the two individuals, the two experts who testified in this particular case, is how they conducted their examinations of Mr. Elliott. As to the defense expert did it in the standard objective, reasonable person. This is an expert who rarely, if ever, testifies for the defense. He is generally someone who testifies for the prosecution and indicates that the person was not suffering, that was responsible for his actions. And here, the expert, Dr. Sabetti, is asking open-ended questions to the defendant to try and get the answers to the questions so that he can make a fair, objective, reasonable determination.
Doesn't this argument sort of go to the weight we should give to the relative opinions of the experts based on, for example, your expert's more thorough examination of the defendant? Is that really our function here?
I believe it is your function, Your Honor, because this is a weight of the evidence issue that's going before this court. And when you look at the examination that was done by Dr. Sternberg, by definition, when you are asking leading questions, you have a preconceived notion as to what the answer should be. Leading, by definition, is leading you to a particular answer. And you see that both doctors come to the same conclusions about the type of mental illness that my client had. Their only difference is to whether or not he appreciates the wrongfulness of his actions.
But counsel, there were a great many witnesses who testified. Am I right?
That's correct, Your Honor.
And you had testimony, for example, that even though the defendant was a person who, I think they're called auditory hallucinations, right?
That is correct, Your Honor.
He experienced auditory hallucinations, and it was known. He was allowed to work in the kitchen where there were knives. He was not considered to be he was not considered to be dangerous. He could be trusted in that way. And you have testimony that you answer. Go ahead. I don't want to go through all my notes because it'll make me crazy.
I agree with Your Honor as to what he did in the past, but I think you have to examine this in the trajectory, the downward spiral that he was undergoing in the weeks prior to this particular sad and tragic incident.
So to that point, Mr. Ferguson, I think what my colleague was getting to also is that wherein I had said, yes, it's a battle of the experts, there was other testimony as well. I mean, there was testimony from his coworkers There was also testimony from his ex-fiance girlfriend, and there was a statement that was made to his mother as well. And there was someone else, I think, from the Salvation Army or something of that nature. But there was other testimony. So other individuals did testify as to his state of mind, for want of a better term, and his appreciation of, right from wrong.
I think, Your Honor, we have to look at it at the date of the incident. The other witnesses are talking about a long-term history as to this individual, as to my client. But when you look at the immediate events prior to it, the fleeing.
Okay, Mr. Ferguson, but what about his actions right after the incident? Didn't he attempt to avoid the consequences? Wouldn't that suggest maybe he understood what he did was wrong, et cetera?
I think Dr. Sabetti indicated that there is some level of appreciation, but that would go to how best would we describe this, as he doesn't completely understand the wrongfulness of his actions, and that when you look at the overall picture, yes, he did certain non-disclosive things immediately afterwards, but that even the psychiatrist indicated that did not foreclose a finding of his lack of the ability to appreciate the wrongfulness of his actions. Would our case be stronger if those weren't there? Absolutely. But the doctor indicated that wasn't an absolute impediment, that the mere fact that these had occurred did not necessarily mean that he could appreciate the wrongfulness of his actions. And go ahead, Your Honor.
And can I jump? Didn't he speak with his mother at the precinct? Can we jump right there?
Oh, in fact, it was almost clairvoyant. That's exactly where I was going, because Justice Weber had pointed it out. And I think what's important there, and it relates to the second point in our brief, is that defense counsel had asked for permission to go to the precinct to look at the setup to enhance the defense. And the people opposed it, and the court denied that request on the grounds that it was a security issue and that the police had full control over the operations inside their station house. So for the people to now claim that it was pure happenstance that my client just suddenly came upon his mother in this police station strains credulity. This is a setup. After my client had invoked his right to counsel, it would be more.
Well, you'd have to show that the police somehow controlled the mother and somehow had the mother put a question to him, because there were no questions put to him by law enforcement. So you'd have to show that somehow she was under the control of law enforcement, or somehow they knew that she was going to say something to him, which would possibly extract some type of inculpatory statement.
I think there's a fair inference. First of all, she was in a place that wasn't accessible to the public, and as they escorted and after my client had invoked his right to counsel.
Let me stop you right there. Let's talk about why she would have been there. Her husband was just murdered by her son.
Oh, absolutely. So no one's disputing that she didn't have a right to be here, but in the location she was, the detective purposely he decides how he's escorting my client. And then as he's escorting him, he doesn't just pass by the mother, he stops and has my client directly in front of his mother, and that the mother then confronts him. I think the logical inference that this is a setup by the police in the hope that he's going to say something. Here you had the detective indicating that even after my client had fully answered all pedigree questions, asserts his right to counsel, and yet then they videotape him answering the same pedigree questions.
Aren't you speculating about what the encounter between mother and son would have been?
No, I'm not. No, I don't think I'm speculating. It is obvious that she's upset. Her son has just killed her husband. And it is, one would expect the mother to do something, to say something to her son, such as, why did you do this? I think
and he could have responded, I didn't do it. I don't know what you're talking about. Anyhow, you have time on rebuttal.
Thank you, Your Honor.
Ms. Kleiner, are you doing it?
Hi, thank you, Your Honor. Your Honor, I agree with Mr. Ferguson that this is a tragic incident, but I disagree that this is actually a battle of the experts. And the reason I disagree is because, as we argue in our brief, if you examine the testimony of the defense expert, it was actually deficient in establishing what, in this case, the defendant had to prove beyond a reasonable doubt, by preponderance of the evidence, which is that he could not appreciate that his conduct in this case was wrong or didn't comply with the moral code of society. Now, what you see here is that we have two experts who really basically agreed on almost everything. They both agreed that the defendant was mentally ill. That's not in dispute. They both agreed that he suffered from schizophrenia. They both agreed that he suffered from an auditory hallucination. And I think it's important to remember where this hallucination occurred. He was back at his family's house or apartment building when he believed he heard his stepfather say to his half-brother, "You should kill the defendant." But it's also not disputed what his actions were then. He waited outside the family apartment. He followed his stepfather for 3 blocks. He then stabbed him repeatedly, even as his stepfather lay face up, prone on the ground. So the crime in and of itself demonstrated that this man appreciated right from wrong, because had the delusion been correct, had he actually heard his stepfather say this to his stepbrother back in the apartment 3 blocks away, he would not have been justified in stabbing his stepfather in the way he did. So this is not one of those cases that we frequently see where a person with mental illness has a delusion that they are faced with imminent harm and they act on that delusion, and it's essentially self-defense if you credit that delusion. Here we have a case where the delusion happened, minutes before, happened 3 blocks away. And when you examine the testimony of the defense witness, the defense expert basically says he didn't appreciate that his conduct was wrong. Excuse me. But if you look at the testimony itself, how does he define wrongness? What he says is that because he had a delusion, he did not realize he was wrongfully killing or wrongfully believing he was at risk from an innocent man. But that's not the standard. The standard is whether he realized that stabbing his stepfather under these circumstances either broke the law or was against the morals of society. And I think not only does the crime itself demonstrate—
why could it not be that he understood that it did not break the law because he was acting in self-defense?
Well, because he wasn't acting in self-defense.
But if the delusion made him believe that he was acting in self-defense because he believed that the stepfather was going to kill him. So it was that he had to kill the stepfather before the stepfather killed him.
I think you have to make a distinction, though, in terms of self-defense. Had he had a delusion that his stepfather was standing in front of him with a gun ready to kill him, yes, then he might have been able to say, I was acting in self-defense. But let's say this was not an insanity case. Let's say the stepfather back at the apartment had actually said to the half-brother, kill the defendant. Could the defendant claim self-defense in a situation where he followed his stepfather for 3 blocks, stabbed him repeatedly, and then stabbed him as he lay on the ground? No.
I've seen cases where defendants have claimed that was self-defense. That was justification. But again, I understand what your argument is, But what about Mr. Ferguson's argument in terms of how your expert questioned the defendant in terms of his testimony and how he questioned the defendant?
I think it's completely irrelevant, and I'll tell you why. Because as we say in our brief, the defense expert himself did not meet this. However, he obtained his information. His ultimate conclusion, his medical conclusion, did not meet the legal standard. He basically said that the defendant could not appreciate the fact that he was stabbing a person who actually hadn't harmed him in any way, but that's not the standard. As our expert and the defense expert medically actually agreed about everything. Our expert understood that the correct legal standard is that if the defendant realized that stabbing his stepfather was wrong and against the law, then he had to be held criminally responsible. And as some of the other justices have pointed out, the record is replete with evidence that he knew that this was wrong. I mean, not just
Ms. Gladden, before you run out of time, in terms of the meeting between the mother and the defendant at the precinct, could you address that specifically? If in fact the police did stage this, law enforcement did stage it, and I don't know if there's anything in the record that states that they did, but if in fact it was staged, and therefore I guess the statement should have been suppressed, it was not suppressed, it was introduced into evidence, is there some type of prejudice there that would result in something less than a harmless error, if anything?
Well, Your Honor, first I have to point out, I have to point out that everything Mr. Ferguson is arguing about that is in contradiction to the fact finding of the hearing court. So to even find that the statement should have been suppressed would involve overturning Justice Bybin's factual finding, which I think her credibility findings about how this was not staged and the explanation for why this was not staged. I don't think there's any basis for the court to overturn her fact finding. However, this was a drop in the bucket in the evidence that the defendant knew right from wrong. I mean, as his conduct after the arrest, he fled from the police, he hid the knife, he told the police he wasn't at the crime scene. So I submit that there is no basis for overturning the fact finding and legal finding of the hearing court, but even if you had a basis, it would not affect the verdict in this case.
And thank you very much. Oh. Thank you. Oh, I'm sorry. Go ahead, Justice Gonzalez.
Your adversary says that the encounter with the mother was staged.
Well, again, the hearing court, I don't know if the court's familiar with all the specific facts here, but I think one of the things that influenced what happened here is this was a family tragedy. It wasn't a case where there was a defendant who committed a crime and the police said, gee, let's get the mother down. Maybe she can get a statement. They were interviewing members of the family because this was a case in which a man had killed his stepfather. And the detective had testified, and Justice Bybin credited that what happened here was he was downstairs processing the arrest in preparation for bringing the defendant down to central booking. As it happened, the mother was in the precinct because the DA was in the precinct at that point, and they were re-interviewing her. So it was perfectly logical that she would be there. It wasn't like the police arranged for her to be there. It just so happens that as they were escorting the defendant upstairs, she stepped out of the office on the second floor that she was in. There's absolutely no indication that it was staged.
Thank you. Mr. Ferguson, you have 2 minutes on rebuttal.
Yes, I would refer your honors to the case of People versus Spratley out of the Second Department. There it was another insanity case. The defendant had been carrying a gun for the entire day, claimed he was hearing voices and needed to protect himself. He essentially stalked the victim, followed him, killed him at close range, and then fled the scene. And there was evidence that he was arrested right thereafter. He indicated he was paranoid and hearing voices, and he thought that the victim was threatening him and endangering his life. That's the same fact pattern as here. And that if this court follows the Second Department's decision in Spratley, then we should prevail. As to the issue of harm, as Your Honors had asked to my adversary, if this was so non-consequential for this to be a factor in the determination of the jury, you need to just look at the people's summation. The prosecutor's summation absolutely references the contact and the statement made to the mother as part of the summation as to why it showed the wrongfulness of my client's actions and his appreciation of it. And lastly, Your Honor, as to sentencing, the issue here is essentially overall, where is my client going to spend the rest of his life? Is he going to spend the rest of his life in a penal institution or a civil institution? The prison system is ill-equipped to deal with individuals who have the type of mental illness that my client has. He got 20 years to life. He's not going to get better. If this court would reduce it to the minimum of 15 to life, he's not getting paroled. What's going to happen to him at the conclusion of his minimum period, if he's granted parole, is the state is going to civilly commit him because he's going to be considered to be a danger to society. So this isn't an issue of he's going to come out and commit additional violent crimes. It is at an earlier point, he would be able to enter an institution that would be more and better able and better equipped to treat him than a penal institution. And under those circumstances, at the very least, we would ask the court to reduce his sentence from 20 to life to the minimum of 15 to life.
Thank you,
Your
Thank
Honor.
you both very
Always a
much.
pleasure.
Thank you.
The next matter is APS Contractors versus NYCHA.
Good afternoon, Your Honors. Gil Namias for New York City Housing Authority. Your Honors, for well over 20 years now, this court has held that contractors must strictly comply with the notice of claim provisions in NYCHA contracts or face waiver and dismissal of those claims. Under the contracted issue, Special Conditions Section 32, plaintiff contractor was required to file a notice of claim stating the basis of the claim as well as the nature and amount of damages within 20 days of their claim arising. The court below, although it correctly dismissed 2 out of the 3 claims raised by plaintiff in its complaint, it committed reversible error by failing to dismiss the first claim raised.
Counsel, why can't the email correspondence between the parties constitute the notice of claim here? Doesn't that put you on notice of what they're claiming, what the damages are, et cetera?
No, Your Honor, it does not. First of all, the email correspondence that is in the record is, it's not even one email, it's several emails spread throughout over a period of time. Section 32 makes it clear that the contractor has to, within 20 days of the claim arising, file with NYCHA a written notice of intention to make a claim for extra costs or damages, stating in such notice the nature and amount of the costs and damages sustained and basis of the claim. You cannot spread throughout several correspondence, make allusion one day to perhaps, well, I'm owed this much, and then another day explain it. It has to be all within one notice of claim. And this court has repeatedly held that in correspondence, when a contractor fails to designate the correspondence as a notice of claim, include the basis of the claim, and state the damages of the claim, that does not satisfy the notice of claim provision. And for that reason, any of the correspondence that was alluded to by the court below could not have satisfied it. With respect to the holding by the court below that the correspondence between NYCHA and the contractor may have indicated a waiver of the notice of claim provision, that is incorrect. As this court has held in SJ Fuel versus New York City Housing Authority and High Tech Construction versus New York City Housing Authority, neither knowledge of claims, discussion of claims, negotiations over a claim, submission of change orders will satisfy the notice of claim provision. Therefore, there is no basis for any correspondence between the agency and the contract to satisfy the notice of claim requirement.
Counsel?
Furthermore, yes.
do you want to address the issue of the extra work, quote unquote, that's being claimed for, and the issue of, for example, the measuring of the railing, that it was the defendant NYCHA said, well, it's the top of the railing, and the plaintiff said, no, I measured everything. It was the linear footage of all of the railing, and I should be compensated for that because this was so much more expensive than what I'm getting paid for.
I think there's two responses to that. First and foremost is that the linear feet unit within the contract specs documents required that is inclusive of all components of the railing, not just each little individual component that the contractor would seek to measure. The other aspect of this is the contract made it quite clear that if there is any ambiguity in the contract itself, the contractor's failure to investigate that ambiguity or raise it at the time of the bid would act as a waiver of any claim of that ambiguity. In this particular,
what about the allegation that with respect to the temporary roofing, the bid document pertained to one building, but lo and behold, the contractor was required to do 10 buildings?
I think, Your Honor, the purpose of the contract and in the schedule of values indicated that the unit prices would be inclusive of the temporary roofing. And as long as that contractor was required to perform the work involved, that would have to include the roofing. The temporary roofing. But again, this gets back to this issue of, to the extent that there was any claims related to that, those claims were waived by the contractor's failure to file a timely notice of claim. So despite the fact that the plaintiff here seeks to argue that their claims have merit, that merit really is irrelevant at this juncture when we are dealing with whether or not the claim was asserted timely under the notice of claim provision. And quite frankly, there is no waiver of that provision because the contract contains a no stopper waiver provision, section 56, which made it clear that no provision of the contract could be waived absent a resolution of NYCHA's board. And here, the record is clear. There was no such resolution, nor has the contractor asserted such a resolution. And absent that resolution, there is no way that section 32 could have been waived. As the Court of Appeal,
you have time on rebuttal. Thank you.
Thank you, Your Honors.
APS contractors?
Yes. Good afternoon, Your Honors. For APS contractors, this is Melissa Salsano with Picard and Abramson. Just briefly, I want to mention that APS is respondent in opposition to NYCHA's appeal to reverse the court's order that declined to dismiss Claim 1 with respect to the portions of the underlying court's order that dismissed Claim 2 and 3. APS cross appeals and seeks reversal of that portion of the decision. I want to start out by discussing something that that is our first point, and our argument is that NYCHA's motion to dismiss, the underlying motion, suffered a significant procedural defect in that the moving paper supplied by NYCHA, its fact affidavit, the gentleman's name is Gene Paul, failed to aver that APS did not timely supply notice of intention to make its claims. Throughout Mr. Paul's affidavit, he references the APS's claims, but he fails to aver that no timely notice of claim was supplied by APS.
Did you file a notice of claim in this case?
So there's two sorts of notice of claim. There's contractual notices of claim, Your Honor, and I can discuss those.
And I'm discussing with the contractual.
Sure.
Under section.
So with respect to that, Your Honor, section 32 of the contract, right, is an informal notice of claim requirement. It does not require a formal notice that says notice of claim. With respect to Claim 1, we submit that our client did supply timely notice of intention to make its claim, and I'd like to briefly explain it and read it to you. That claim could have arose no sooner Then July 6, 2016, when the NYCHA's construction manager, TDX, informed APS that it was going to measure the linear quantities with respect to claim 1, which was temporary railing, abatement of roof railing. They indicated that they were going to, that AP, quote, this is from record 1024, APS is not permitted to count the 34-inch tall vertical railing post as a linear foot quantity over and above the 500 linear feet. That email goes on to direct APS to modify its payment application. Immediately in response to that, less than 24 hours later, at record 1030, APS supplies the following by email to NYCHA and to TDX. Just to confirm what was discussed, APS accepts to use TDX's quantities for the lead abatement and painting of the railing for the time being only, for the sole purpose to process the payment for work performed in the June pay period. APS does not agree with the way how TDX is calculating the quantities on these two line items, work item 2.18 and 9.2. However, APS reserves the right to look for proper full compensation of this work performed as per the contract documents.
Counsel, if you could just stop right there. So when it says, when APS said on July 7th of 2016 that it reserved its rights, do you understand that to mean that it could file a notice of claim at any point in time because it had reserved its rights? Or do you understand that it had 20 days from July 7th, 2016 to file a notice of claim?
My position is that from July 6th, when NYCHA and it's TDX on behalf of NYCHA informed APS that it would be measuring the quantities this way, that APS had 20 days from that time to supply its contractual notice. The statutory notice, we don't dispute that notice, as I understand it, there's no dispute that notice was timely supplied. So if we're talking about the contractual notice, my position is that the notice at record 1030, the email that I just said to you that says we reserve our rights to look for full and proper compensation of this work is, and that this email satisfies the notice of claim requirement.
But does that, you know, your adversary, and I'm not going to repeat what he said, he quoted the section 32.8. Does that email fairly put them on notice with respect to what was required in the notice of claim?
I believe if you were to read the correspondence, and I can discuss some of it here, that NYCHA and TDX throughout after this correspondence, this is a long, lengthy span of correspondence, right? They understand, NYCHA and TDX understands exactly what APS is claiming. There's an email on record 1034. I'm reading just a part of it as a quote, right? As marked up, the contractor claims that they're entitled to be paid approximately 2,117 linear feet at each I-shaped building for both the painting of the perimeter roof railing and infill panels. So there's more to that email. I'm just giving you a snippet, but the construction manager and NYCHA are clearly aware of the claim. With respect, and further, the direction from the day before from TDX on July 6th, that's at record 1024, tells APS, you're not getting paid and we're not approving this payment application until you reduce your payment application by the amount of quantities that's disputed. So this is a different scenario than where if a contractor does extra work, supplies a notice to an owner that says, oh, I found this differing site condition, or I had a different problem, where the owner is not on notice of it. This is a different scenario. Here, NYCHA and its construction manager have directed APS to reduce its payment application by a disputed value. Everybody understands what the disputed value is. Everybody understands what the contractor's claiming. With respect to my adversary's point that the notices, I can discuss the other claims and the notices. That the section 32, nowhere in that notice provision does it say that the notice needs to say notice of claim. Does it say that the notice needs to come in one transmittal? And in fact, the writing of the language of section 32, which is NYCHA's own contract, connotes an impression that it's an informal requirement because it requires only a quote notice of intention to make a claim. It doesn't ask for a notice of claim.
I thought under section 32, it was supposed to be a single document which expresses a clear intention to bring a claim. Is that not the requirement? And also that it has to clearly state that it be designated as a notice of claim, as well as contain all of the information required by section 32 of the contract in a single document, and express a clear intention by plaintiff to bring a claim against the defendant?
Your Honor, respectfully, it does not require the words notice of claim.
I'm sorry. I'm sorry to interrupt you, but 32B says specifically by the filing by the contractor of the notice of claim. Don't we have to read A and B together?
I think that A is connote, like I said before, and I don't want to repeat myself, and I apologize, but my point would be that it's only requiring section A, right? It's only requiring a notice of intention to make a claim, right? If what's required is ambiguous, then that should be construed against NYCHA, who drafted the contract.
But how is it ambiguous? Because 32B goes on to say that the filing of a notice of claim is a condition precedent. So read together, it sounds like my colleague is saying that the intent of the contract is to require a formal or some kind of document. Well,
there was a prior. I'm sorry.
That's all. Go ahead.
This contract, I'll say that this notice provision is starkly different than the notice provision that NYCHA had in its contract with respect to the AHA decision that they rely on, and they say that there's a lineage of cases, which I'm happy to discuss how those are all different from this particular scenario.
You can discuss all of those cases on rebuttal.
Okay, well,
counsel, you have.
Can I just,
no, you can respond on rebuttal. You have NYCHA. You have 3 minutes in rebuttal, and you're muted. Still muted. There you go.
Still muted.
Still muted. One more time. There you go. Don't
Am I good?
Anything. Okay.
I'm so sorry. I hope that's not counted against me, but I will make this as quick as possible. Very quickly. First and foremost, with respect.
Your adversary does make a valid point. With this flow of emails, it was kind of clear that there was an issue. In terms of what they were requesting, what was being done, etc. So why was this not sufficient notice under Section 32? And why is it that we have to read Section 32 as a single document, as requiring a single document, as opposed to just a email chain?
I think I'll address that quickly on 2 points. First and foremost, in terms of the provision itself, it is clear that the contractor must state the basis of the claim and the damages in the notice. It has to file a notice of claim within 20 days and state those things in the notice, not state those things in separate writings. Second of all, this court has repeatedly interpreted the exact same language contained here to require that the notice be designated a notice of claim, B, must include the basis of the claim, and C, also state the damages. None of the emails pointed to here do that. Even if you credit this argument that a reservation of rights states an intent to make a claim, there was no inclusion of the damages within any of those documents. And with respect to what NYCHA knew, this court has repeatedly held that is irrelevant. The requirement here is that a notice of claim must be filed within 20 days of the claim arising, which I will dispute that it arose on July 27th because NYCHA told the contractor on April 20th of 2016 what its interpretation of the contract provision was. This was just merely a continuation of APS's attempts to get NYCHA to change its mind. In regards to very quickly to whether or not we had stated the grounds for the motion, the notice of motion was very clear that Section 32 was a basis. The attorney's affirmation accompanying the motion also indicated quite clearly that the notices of claim were untimely, and that alluded to the notice to the memorandum of law. Also, that argument was not raised below until the motion to re-argument, which at that point would be inappropriate and therefore should not be raised upon appeal. Very shortly, Your Honors, here, the court below committed grievous error, as in most recently, just a month ago, this court rejected the very same types of arguments made in Universal Construction versus New York City Housing Authority 2021 Slip Op 01372. And at this time, I'll rest on the remainder of our brief.
Thank you so much. Ms. Alsano?
Sorry, so just going back to the point about that the claim 1 arose in April of 2016, it wasn't, like I said before, it wasn't until July 6th that NYCHA unambiguously communicated that they were measuring the units this way. With respect to the April email, I'll read it to you. It says, that email describes that NYCHA was going to approve and measure the quantities exactly the way that APS intended for it to be measured. So it wasn't clear until July 6th that there was a change or that there was a dispute. The April email on record 1016 says, accordingly, for every 1 linear foot of lead-based paint removed from the roof railing system, round rail pipe at the top of the system, round pipe posts, etc., APS will be paid the agreed upon unit price. It wasn't until July 6th that NYCHA and TDX communicated that they were only going to pay 1 unit per top rail to abate all of the linear footage below. There's a couple of other things that I need to unpack and discuss if you just give me a moment. With respect,
I would like to ask one question before you unpack, and that is, I recognize we're reading this as a chain of emails. Do they specifically state what the damages are?
I think that the damages are,
because I thought Section 32 also stated that there had to be some there had to be an indication of exactly what the damages are that you're claiming.
I'm sorry, Your Honor.
Go ahead.
I think that the damages that in the claim value is framed entirely by the correspondence. In the July 6th email from NYCHA, this is with respect to claim 1, they directed APS to reduce told them they're not getting paid until you reduce the value of your payment application by the disputed quantities. So it's not like I said.
Counsel, but is there a number somewhere?
Within the correspondence?
Somehow in any of these emails, is there a number as to damages?
There is numbers of quantities that are claimed.
No, like numbers of dollars.
Within
the exact amount of damages. Do we have to do the math and go through each email and cipher out an amount and then add that up and then that determines that those are the damages? Is there anything specific in terms of exactly what the damages are?
So the damages would have accrued over time, right? So this first payment application that was reduced, the damage at that point would have been the amount of quantities that they were directed to reduce multiplied by the schedule of values for that item, which I think there's 2 schedule values. I think it's about $40.
So the question is does that appear in the emails, or as Judge Weber is suggesting, you're going to make the judges do the math?
No, I'm not suggesting, Your Honor, that the judges should do the math. It's actually in NYCHA's email during this correspondence where they say, quote, the contractor claims they're entitled to be paid 2,117 linear feet at each I-shaped building. Everybody knows what the unit price is.
So I have to multiply the linear feet by the amount and come up with what the amount is, right? I have to.
Yes, I can give you. I'm sorry, Your Honor. I can give you.
I have to do some kind of multiplication. That's multiplication, right? So I have to do some type of multiplication, right, to come up with the number. My point is, it's not only the judges doing the math, but also I thought that the notice also would have to give them a specific dollar amount as to the damages.
Your Honor, I'm not suggesting that I'm not being unwilling to do the math. The total value of, I know what you're getting at, just so I provide the number. The total value of that claim is a little over $1.4 million. But with respect,
so does that number appear in the correspondence?
It does not appear in the. I'm sorry, did I interrupt you?
No, no.
That number does not appear in the correspondence, but it does appear in the statutory notice of claim that was supplied at the end of the project when all of the dollars were able to be determined, that the disputed quantities total were able to be determined. There's a couple other things I wanted to address. With respect to counsel's argument that that claim arose in 2016, that's not accurate. The record at 1016 explains that it wasn't until July that this issue was communicated unambiguously to the contractor. With respect to the argument that was made below and that the lower court portion of its order relied upon, which was the case called Huff Enterprises by this court, and the court below declined to dismiss Claim 1 on that ground for the reason that Huff Enterprises explains that the course of conduct between parties related to correspondence, if it's sufficient, that there could be potentially a waiver by the agency with respect to that.
You raised the issue of waiver. Isn't there a very specific requirement in the contract of how a waiver is procured?
I think that the section that counsel references, which is section 56, that waiver it applies to acts done by the authority. It doesn't apply. We're not claiming here, APS is not claiming that this was an action done by the authority. We're claiming that this is a waiver by operation of law. Just further on that point, we're not asking the court to determine at this point that there is a sufficient amount of correspondence if the court doesn't agree. We're just asking to be entitled to discovery on this and to proceed past a pre-answer motion. The Huff Enterprises case was decided at summary judgment level, and so was the other case, AHA. With respect to counsel's argument that the contract documents required the contractor to raise any discrepancy or ambiguity with respect to the contract documents at the time of bid, he didn't say what the section that he's referring to, but to the extent that he's referring to section 4D of the contract that was discussed in the briefs, that section applies to discrepancies with respect to quantities. The discrepancy here with respect to claim 1 is a discrepancy with respect to measurement. Even if you contend, or he contends, that that's an issue with quantities, as I set forth in my brief, the form of bid document, as I understand, controls over that, tells the contractor if there is a discrepancy with quantities, if there isn't, I think the word used is discrepancies, if there's a discrepancy, that it directs the contractor that the schedule of values controls.
Thank you very much, counsel. I'm sorry, your time is up. Thank you both very much.
Thank you.
The next matter on for argument is Diaz versus HHCTS REIT.
Good afternoon, Your Honors. May it please the court, my name is Lauren Donnelly and I represent the appellant SJ Electric in this matter. The lower court erred in granting plaintiff's motion for summary judgment pursuant to Labor Law 240 and in denying SJ Electric's motion for summary judgment. Plaintiff's motion for summary judgment should have been denied for various reasons. First, plaintiff failed to demonstrate that at the time the pipes fell, they either were being hoisted or secured or required securing for the purposes of the undertaking. In order to determine the applicability of Labor Law 240, courts don't simply examine whether an object fell, but also consider whether the object fell, was being hoisted or secured, and the task that the plaintiff was performing at the time of the accident, and whether a securing device was of the type enumerated in the statute.
So are you arguing that plaintiff must be working on the object that fell to trigger liability?
That's a consideration. You have to take a look at a totality of the circumstances.
But aren't there a number of cases where that's not a requirement?
There are some cases, it's dependent on the facts of the case. And in terms of this case, plaintiff was stripping forms and he was not working on the object that fell. The pipes were not being hoisted or secured, and they were not being moved vertically or horizontally at the time of the accident. But in addition to that argument, plaintiff's motion for summary judgment should have been denied because plaintiff failed to establish that the pipes was not a foreseeable elevation risk in light of the work being.
Counsel, I have to say that I'm just astonished by your argument. You're talking about someone working in an area who is hit on the head by, what is it, 8-foot long or 10-foot long pipes, 3 of them? He's hit on the head, and you're saying that the labor law doesn't provide him protection from falling objects such as these that are allegedly unsecured in some way?
I'm not saying that. What I'm saying is questions of fact are raised as to whether Labor Law 240 applies in this particular.
Well, so what's the question of fact? It's gravity related. There's a height differential between, it's an 8 to 12 foot pipe. The testimony varies. The plaintiff clearly is not 8 to 12 feet tall. Isn't there a height differential, gravity related? What more needs to be addressed?
Well, in terms of the height differential and whether it was physically significant or de minimis, the record doesn't support any that. There's conflicting testimony as to the type of pipe that was used, the height of the type.
Well, okay, at minimum 8 feet, right? Minimum 8 feet. Are you alleging the plaintiff was 8 foot tall?
No, what I'm saying is that no one saw the pipes before the accident happened. So we don't know the exact position. We don't know whether how they were leaning, if they were leaning, and the differential between the top of the pipe, because we don't know whether it was an 8-foot pipe or a 10-foot pipe, and how much it fell. So you have to consider that. We don't know the weight. Those are considerations that are given.
Well, let's talk about the weight. My recollection of the record is that the plaintiff was knocked unconscious, that the force was sufficient to dent his hard hat.
That is in the record, Your Honor. You're right. But there was, I mean, you just can't take a look at whether the object fell. You have to look at other considerations. But also in terms of plaintiff's motion, we have to look at whether there was approximate cause of the accident. And here,
I'm sorry, whether the plaintiff was approximate cause of the accident?
Whether the violation was approximate cause of the accident. I'm sorry if I misspoke. It's really just based on pure speculation, but also you have to consider that a jury can conclude that the plaintiff was the sole proximate cause of the accident. In this case, plaintiff was pulling out a plywood form and it was stuck. And instead of determining why it was stuck, he pulled on it, and that is what caused the pipes to fall.
Well,
So,
but couldn't one argue that the reason the pipes fell is that they weren't secured as they should have been under the labor law when plaintiff pulled at the form?
well, that it could have been just the opposite. It could have been that the plaintiff's pulling of the plywood caused them to be unsecured. So in terms of plaintiff's labor law.
What does that matter? I don't understand. Why does that matter? If the pipes are unsecured, plaintiff pulls on the form and the pipes topple on him. That sounds like a violation of the labor law.
In terms of this, nobody saw the pipes. So there's testimony that they were loose, but no one saw the pipes as to whether they were secured or not prior to the accident. So, and based upon that, the plaintiff's motion for summary judgment should have been denied as questions of fact. In terms of SJ Electric's motion for summary judgment, that motion should have been granted. There has been no evidence except for pure speculation that these pipes were electrical conduit. Both Mr. Simpson and Mr. Diaz testified that they had no knowledge as to what the pipes were being used for or who brought them to the 25th floor. Plaintiff never saw the pipes before. There's evidence in the record.
There was testimony that didn't SJ Electric concede that it used conduit piping that matched the plaintiff's description of the pipes that fell on his head?
Yes, but not on the 25th floor. The 25th floor was a mechanical floor, and they were not using electrical conduit on that floor. But
This was silver piping, and there was no evidence that the pipe that's used by plumbers or sprinkler installers or anybody else was being used, right?
That's the mischaracterization of some of the testimony. Mr. Gonzalez even said he could not even, who's the Lend-Lease foreman, did testify that he could not identify whose pipes they were, and that steam fitters and HVAC contractors also used similar pipes.
So that would be an issue of fact, right? Would that not be an issue of fact?
Well, it's only a speculation that it is electrical conduit.
But I thought the testimony also was that these electrical conduit pipes would be taken to the floor either the day of or the day before they were going to be used. So it could have been that they were taken to that floor because it was going to be used that same day or the next day.
The 25th floor at the time was a controlled access zone. No one besides Pinnacle, plaintiff's employer, was allowed on that floor while they were stripping the forms. But
they stored property on that floor. Didn't they store the pipes on that floor?
They did not store the pipes on that floor. There's no testimony in the record that the pipes were stored on that floor. And even Mr. Gonzalez couldn't testify that he didn't know whether the pipes were being stored or were debris.
You have time on rebuttal. Thank you.
Okay. Thank you.
Good afternoon, Your Honors. My name is Paul Maloney with the law firm of Edelman and Edelman, and we represent the respondent, Mr. Diaz, the plaintiff in this case. With respect to some of the questions that I've heard, there was a case called Harris against 170 East End Avenue. That's a 2010 First Department case where a steel worker was struck by falling debris. The debris was left by concrete workers, and what happened was you had the crane, which was moving the steel. The cable of the crane came in contact with the dunnage. In this case, they were 4x4 wooden stringers that were 16 feet long that were allowed to protrude from the building. The point of that case and how it's relevant here is that you had a material that was placed on a floor by one trade that was not properly secured or protected, and it was that material that struck, in this case, a steel worker. Mr. Diaz's fact pattern and his accident is basically the same as what happened to Mr. Walensky.
How do you address your adversary's argument that essentially the height differential is de minimis, or at least as an issue of fact whether it was de minimis?
Mr. Walensky was 5'8". Mr. Diaz is just under 5'10". Mr. Diaz was struck by 10-foot falling pipes. Mr. Walensky was struck by 10-foot falling pipes. The proof in Walensky is that there was no specific proof as to exactly the weight or exactly the length of the pipes, same as there is in this case. The Court of Appeals noted in the footnote in Walensky the exact height of the plaintiff and the exact height of the pipes that they accepted. The facts are exactly the same here. Mr. Diaz is 1 3/4 inches taller than Mr. Walensky. The court below, the motion court in this case, relied upon that, cited that specifically.
What about your adversary's argument that your client was the sole proximate cause as he was tugging or pulling out the plywood that caused the pipes to fall?
Mr. Diaz's testimony at page 174 of the record is that he gave it a nudge. But even if you want to accept the fact that, look, these are construction workers and he's pulling on the pipe with some significant force, in order for the defense, in this case, the third-party defendant, to establish that the plaintiff was the sole proximate cause, they would have to meet the Gallagher factors, which would be that the plaintiff knew that there was a safety device that was available to him, that he intentionally did not use that device, and et cetera, et cetera. None of that was established in this case. And again, the motion court specifically cited that which is correct in this fact pattern, that the plaintiff could not possibly have been the sole proximate cause. He didn't put the unsecured 10-foot pipes there.
And finally, as to your client's argument that SJ Electric, in terms of what is there in the record to connect these pipes to SJ Electric?
It's an interesting question. It's not specifically the plaintiff's burden. We don't have to prove whether they were electrical pipes or plumbing pipes or anything else. But if you take a look at counsel's own witness, Mr. Amabile, he testified at page 423 of the record that they did have 10-foot electrical pipes that were 4 inches in diameter. That's their own witness. The last thing that I think that is important, because the briefs are replete with the testimony of all of the witnesses that these pipes needed to be secured. But if the court takes a look at page 432 of Mr. Amabile's testimony, which unfortunately is 4 pages of his deposition, but it's the very end of his deposition at pages 54 and 55 of that EBT. Mr. Amabile, who is the supervisor for SJ Electric, says when it comes to safety and securing and storing their pipes, these pipes can't be just thrown around. And the reason for that is, as he says, there are 5 to 6 other trades working on the floor. This is a high-rise building. We can't leave our equipment in such a position that it could harm others.
Thank you very much, Counselor. Ms. Donnelly, you have 2 minutes on rebuttal. Muted.
Just a few brief points, I'm sorry. The plaintiff it can be held that the plaintiff is the sole proximate cause of an accident when the plaintiff defines the task at hand, chooses the means and methods to be used, and makes the decisions that led to the accident. And in this particular case, plaintiff was the one that went to remove the plywood form. He's the one that pulled on it, and when it did not come free, he pulled on it again instead of determining whether what was in the problem. In terms of SJ Electric's testimony was that the pipes would not have been brought up to the 25th floor at any time prior to the forms being stripped. And also, like I said, it's a controlled access zone. They would not have been allowed to be up there. And also, if they would have had to have asked Lend-Lease permission to store them on any floor or at anywhere. And there's no evidence in the record that a request was made or that a Lend-Lease provided them with authority to store or put materials up on the 25th floor. So for the reasons that we've stated in our brief, the plaintiff's motion should have been denied and SJ Electric's motion should have been granted.
Thank you very much. Thank you both. Thank you. Next matter is Tudor Perini versus City of New York.
May it please the court, Jim Barrier with the law firm Hinckley Allen for Tudor Perini. And the issue in this case is whether there's a cardinal change where a New York City agency puts a $100 million bridge project out for public bid, awards that project to a contractor, abandons that project, and then directs the contractor to redesign an entirely different bridge project.
But it's a bridge. It's a bridge.
A bridge is a bridge. That's what the city is arguing in this case. But isn't that correct?
I mean, the contract was to put in a bridge, and that's what got put in. The design changed, but that's what got put in.
Respectfully, Judge, under Westcott, a bridge is not a bridge. Under the Crane-Hogan case, a bridge is not a bridge. And under a recent case in New York City, it was held by Judge Ramos, he also found that a bridge is not a bridge because they get into the essential nature and characteristics. That case is North Star Construction in our brief. A bridge is not a bridge. And I'll tell you what's even more important about this case. The design of the bridge is an essential function on a public works project. On a $100 million project, who designs, who's responsible and obligated? is a huge function of that job. And here the city placed that design of the entire project on my client. So even if the court is to accept a bridge as a bridge and not follow Westcott, not follow Crane Hogan, not follow North Star, the design transfer in this case is a cardinal change. And it is unprecedented on a project of this size to have occurred.
Now, in this case, there's a provision, I think the civic provision.
Yes.
Which was utilized to take the change. Presumably you benefit, your client benefited from the change because you share in the savings, correct?
Well, we benefited from the change under the first 3 change orders that were issued under that civic clause. We lost about 22 million under the last 4, which I'll get to in a minute. The civic clause is a value engineering clause, which is designed to have the contractor help the city save money with respect to the construction of the project. And there is a sharings component to that. But the civics clause importantly says, the civics clause cannot be used to impair the essential functions and characteristics of the project. That's at 593.
But counsel, didn't the navigational area, the minimum vertical clearance, the width and the number of the traffic lanes remain unchanged as to both designs?
I would ask the court to take a look at page 440 of the record and compare that to page 442. What you have on page 40 is a depiction out of the city bid documents of what the cable stayed bridge was supposed to look like.
I looked at those pictures.
You'll notice, Your Honor, that the bridge was never going to enter the water at Eastchester Bay. It starts on one shore, ends on the other. It's suspended entirely by hundreds of intertwined steel cables, right? The bridge that was built and redesigned by my client at the city's direction
was cheaper and involved ostensibly less work. And as my colleague indicated, there was a considerable savings that was effectuated. But weren't design changes incorporated into your contract? Wasn't that part and parcel of what you agreed to cover?
Couple of things real quick. The design changes we agreed to cover can only be found in the civic clause, which are, again, changes that are not used to impair the essential functions and characteristics of the project. When you build a bridge,
and the essential function of this project was to get people and goods and trucks and et cetera from one side to the other side.
The essential function of the project, right, is to design and build a bridge for those purposes, as you stated, Your Honor, with the city designing and my client building. That essential design function was transferred to my client. That's a cardinal change. With respect to the characteristics of the bridge, there's a big difference between a bridge that is suspended from above and one where you enter the water all the way down to the bridge bed through piers. In Westcott, they only lengthened the piers. Here, they completely added the piers. So now you're in the water 8 times with separate piers under 2 support structures. And if you look at the test under Albert Elia,
but counsel, even with all of that, doesn't the cost tell us something? Doesn't the cost of this inform us that this was a simpler design? It did save money. It really did not affect the essential function of a bridge, which is to pass from one side to the other.
But here's my point. Again, with respect to the bridge structures themselves, there was a savings. There absolutely was. But my client didn't benefit on the project because it wasn't paid for the extended performance time to build this bridge. So my client lost in the black tens of millions of dollars. So sure,
didn't you negotiate this clause that said that you wouldn't be compensated if there were delays?
No, that's not what occurred. And I'll get to that. Under Article 13.1 of the contract, right? And that's found at the record at 202. We need a change order in order to extend the performance time. And if we don't get that change order, we're subject to liquidated damages under the record at R207.
And you got 4 extensions.
Right. And every time we got an extension, we said we have an excusable delay. You have to tell them why. We said we have an excusable delay because we had to redesign this bridge and build a new one. And by the way, it's going to cost more money over this extended performance period. We're not sure how much, but we're going to reserve the right in these discrete cost categories. The city authorized the work. They said, fine, you get more time. They allowed us to reserve our rights. They didn't tell us at the time, oh, by the way, you're never going to get paid because, we're just going to invoke a no damage for delay clause. They only did that after they got their bridge, after my client lost over $22 million, and after their bargain was given. So why does the contract entitle me to payment for this? Because it's extra work. Under section 2.115 of this contract, work other than that required by the contract at the time of the award, which is authorized by the commissioner, is extra.
But
And
isn't
under
it predicated,
it tells me how to get paid.
on
I'm sorry, Judge.
delays? Counselor,
Sorry.
isn't it predicated on delays? The extra work is predicated on delays as a result of the design change, et cetera, no?
The extra work is predicated on the entirely new bridge project that the city made us design and build. That is correct. And the reason why it's a cardinal change, and I'll be brief because I'm running out of time.
No, you've run out of time. You've actually run out of time. But
may I just cite one Court of Appeals?
Just finish this one point, please.
Okay, Litchfield, Court of Appeals case is far back as 1926. Changes in the drawings might alter the manner in which such work was performed, but changes in the drawings could not change the description of the work itself as contained in the contract. It's an entirely different bridge. Thank you.
Thank you.
Good afternoon. May it please the court, Lorenzo De Silvio on behalf of respondents. 3 points underscore the rationality of the board's decision here and undercut Tutoperini's arguments. First, I heard Tutoperini's counsel rely on the civic clause. You can't impair the essential functions or, you can't impair the essential functions or characteristics of the project or any portion of the work involved. Definitionally, you can't have an extra work claim if you go the civic route. They're just not compatible. Moreover, you can't under civic claim costs related to implementation of that proposal, and that's precisely what Tutoperini seeks here.
Your adversary says that changing the design of the bridge from a, I got to get this thing right, cable stayed bridge to a causeway bridge is a huge change. It turns everything around. It's extra work, and you're ripping him off, your client.
Your Honor, that's inaccurate. First of all, that would swallow the rule. The exception would swallow the rule to say that any changes to the design mean cardinal change or extra work.
Well, no, I'm saying it's a material change.
Yeah, we're talking about material change.
That's right. And so DOT doesn't dispute that there were changes, but not a cardinal change that fundamentally altered the essential identity or main purpose of the contract.
This is not a cardinal change where you're talking about now being in the water and previously you were out of the water, now you're actually in the water? That's not a cardinal change?
No, it's not, Your Honor, because it's still, first of all, it's still a bridge to City Island. It's always been a replacement bridge. And even if you disagree with that, there's still deference owed to the expertise exercised by the agency here, and rationality is the standard. Moreover, there's a rational basis to distinguish each of the 4 cases that Tutoperini relies on. None involved Article 78 deference to the determination of an expert agency. And 3 of them, North Star, Litchfield, and Albert Elliott, either expressly or implicitly recognized that a change in the method of construction or in the manner of performance, that's okay. That's not a cardinal change. And as this court determined in the Laws case recently, if there are increased costs due to design changes, that's a delay damages claim. That's not a claim for extra work. And the last thing I would say is just push back on the assertion of Tutoperini that they were somehow forced into this. Tutoperini is a sophisticated commercial entity. They knew what they were doing and they chose to go the civic route rather than risk a rebid under a contract that it might not win. I think the final point I'll make is that there's an irony that Tutoperini is relying on the Albert Elliott case, because that case says if there's a cardinal change, you actually have to rebid the contract. And if you don't do that, what happens is the contract gets voided and potentially the money's paid to the contractor gets clawed back. Even under that case, it doesn't get the compensation it's seeking here. Rather, as the Court of Appeals has explained, these rules may be harsh, but they're designed to strictly police costs when it comes to public sector construction projects to protect the public fisc. And Tutoperini just has not shown irrationality in the board's decision here.
Can I request 10 seconds?
No, you can request it, but it's denied. But thank you very much.
Thank you, Judge.
Take care. The next matter for argument is 400 East 57, fee owner.
Good afternoon, Your Honor. This is Benzion DeFunis for the Appellant 405 East 56th Street LLC. We're here today on a appeal from a decision granting a RPAPL 881 license to 400 East 57th to enter onto the property of 405 East 56th Street in connection with certain work that they were doing to their building that they needed access for to our building. Now, the decision that we're appealing from is really not a decision, but more of a court-drafted license agreement that contains numerous instances of error. The most egregious one is, of course, the grant of access to the interior portions of our building.
Counsel, isn't that mooted out at this point? That issue is mooted out.
Your Honor, it's not, and I'll tell you why.
Why is it not mooted out?
Okay, there's a few reasons why. I think the first one is if you look at page 8 of their brief, they don't really say they don't need access. They say we don't believe right now, but maybe we will in the future, and we reserve our rights to get that access.
So they'll make an application for access if it's needed down the road. But at this point, why do we have to address that issue?
Well, let me give you another reason, because we asked for, and this is not on the record, but as this is outside the record, but we asked for an adjournment.
So we don't discuss things that are outside the record. We stay within the record. So let's go to the terraces. Was there any discussion or least intrusive design, et cetera, which would deal with the terraces, the overhang for the terraces?
Well, you're on. There's 4 terraces that we're dealing with. These are terraces that are attached to individual apartments, and the tenants have the sole right to use these terraces. Now, what the neighboring owner has done he's constructed a controlled access zone on each terrace and placed roof protection on there, and now the tenants cannot access the terraces at all. They're precluded from using it.
Did they agree, counsel, to use a less intrusive means of protecting the terraces?
No, Your Honor, they did not. And then there is a less intrusive means. That is overhead protection with
netting.
With netting, and that would allow the tenants to go onto the terraces and in fact use them.
So let me understand this. The 400 is going to use a crane and avoid going through the interior of the building. They're not also agreeing to change the method by which they're going to protect the terraces?
That's correct, Your Honor. And in fact, the protection has already been installed on our building. They were able to apparently use the crane to place the protection on the terraces and on the roof of our building. There's also other areas that are protected, which a crane is not needed for. But the protection has already been installed as of, I think, January, the first week in January or so of this year.
So they have overhead wood on the terraces?
They have, no, they have roof protection, which is consistent of styrofoam and some type of and plywood placed on the terraces.
Oh, can the tenants access the terraces or not?
No, they cannot. It's a controlled access zone per their site safety plans that they've submitted. It's a controlled access zone, and all 4 terraces are inaccessible to the tenants.
And so the licensing agreement did allow for reimbursement to the building if those tenants wish to have some type of abatement of their rental or the carrying charges, whatever. Is that correct?
What the license agreement does is it does permit the landlord to make a claim against I'm sorry, not the landlord, 405 East 56 to make a claim against the neighbor for rent abatement. In the case of the tenant seeking a rent abatement, but it caps that at 25% of the rent. So, for example, the tenant's going to come and say, "This is the most important part of my building, my apartment. I want 100% abatement until this is off." The court says, "No, you can't do that. It's going to be capped at 25%, even though we have to go and give them 100% abatement." And that may be the case even if we have to go to court to defend against that, and we're going to be forced to give them the 100% abatement, only recover 25% abatement, and that of course violates the rule that as the adjoining owner, we're not supposed to incur any costs in connection with the neighboring's access to our property.
Thank you very much. Yes, Mr. Kopp.
May it please the court, Howard Coe for the respondent. The cases make clear that the standard the court should review this is an abuse of discretion
So let me ask you, Mr. Coe. So you have two experts here. Your expert says you need roof protection, as you put forth. Your adversary says there's simpler ways to do it. Tenants can access it through plexiglass panels and netting, et cetera. Why shouldn't there be a hearing on that issue for the court to decide which expert to accept?
The court felt there was no need for a hearing, probably because of the thinness of the record in my adversary's assertion that this could be easily done by overhead netting and plexiglass panels. The reality is that it's not necessarily the most least intrusive means. There's a reasonability standard that goes on top of that. What is not in the record.
Fair enough, but shouldn't the court have made some factual findings with respect to the issues you're raising, that that your proposal is reasonable, et cetera, and that's the best way to do it?
Well, I think the court implicitly did make the factual finding that it is reasonable.
Without a hearing.
Without a hearing. But
I understand this is COVID, but but there is due process, no?
Oh, I understand that. And one of the things that due process is, Justice Singh, is that you really need to give something more than an allegation that this could reasonably happen. They have their in-house construction person, who was the affiant who made this argument, saying, oh, they can go out there and they can put up netting and plastic. Doesn't address the cost, doesn't have a proposed design submitted.
Is that what a hearing is for?
A hearing is for.
So those factors can be weighed, because you're talking about the denial of access to the terraces, and it's during the time of COVID when every itty bitty part of air and light is important. How do you decide it's on paper?
The answer is I would agree with Your Honor if there was a robust showing that there was really something here. What is missing here is there is not a robust showing that this plan to do it in a less restrictive means should be given any credence. One of the things that that Justice Ngoran remarked about is that the appellant here was very uncooperative until we had to bring this to court. We didn't hear about this restrictive means, least restrictive means or alternative plans throughout the negotiations that took place from January 2018 to 2020 to June 2020, when they were simply saying, no, what we really want is for you to give us an indemnification and a $5,000 a month license.
Is there any burden on you? Is there any burden on you to come up with a plan that would be less intrusive to the tenants?
Yes.
Burden on you to show that this is the only way in which you can proceed with the modifications, the renovations?
Yes, my independent construction consultant provided an affidavit that said this was the best way to go. And that is an important distinction from their consultant, whose salary is paid by the managing agent of the owner.
And so plexiglass would not work, right?
The answer is there's no evidence in the record that it will at a reasonable cost. That's the answer that I think that we can give you. And I would say it's their burden to show that if they've got a better way to do it, they should tell the court about that before they come in and say, we want a hearing, not afterwards.
Now, Mr. Cohen, another point raised by your adversary, which frankly I'm somewhat sympathetic to, is if a tenant claims 100% abatement and were to be granted by a court, by a housing court, why should the adjoining property owner be essentially responsible for 75% of that abatement?
The answer to that is, I think you've constructed a scenario which seems to me that is quite frankly impossible. And I don't.
But answer the question as asked. I mean, you say it's impossible, but if the court were to grant that, shouldn't you be responsible, or your client responsible, for the abatement, the entire abatement?
The answer is I could see that argument. I'm going to say no for these purposes because I mean, you're postulating a situation where a New York City tenant is saying, well, I don't have to deal with the fact that New York City and Manhattan residents live on top of each other. Your hypothetical does ask us to accept that a New York City tenant will be able to walk into a housing court and say, Your Honor, even though I am living in the apartment, I shouldn't have to pay any rent.
As my colleague mentioned, it's a little different where you're talking about COVID and you're talking about quarantining and you're talking about the need to go outside. And so I can see during the pandemic wherein someone would actually want to go out onto the terrace because they can't actually go out on the street without wearing a mask. And so maybe they don't want to wear a mask and they want to go out on the terrace. But anyhow, your argument is well taken. Thank you very much. Any additional questions by anyone? No? Thank you so much. The last case for argument is Chester County versus Allian Pharmaceuticals.
Good afternoon, Your Honors. Michael Hines on behalf of Appellants and Alnylam Pharmaceuticals. In this Securities Act case, plaintiff alleges that 2 categories of statements, 6 statements in total, contained in documents associated with the public offering of Alnylam common stock were misleading. And the first category consists of a single statement that, quote, patisiran achieved significant effects in the study's cardiac subpopulation, including on disease biomarker, echocardiographic, and functional parameters. And the second category consists of the remaining 5 statements, variously stating that Apollo achieved positive complete results or positive data. That's it. No other statements are alleged to be false or misleading. But those statements are quintessential statements of opinion about clinical trial results that are not, in any event, adequately alleged to be misleading. And I'll address the challenge statements as opinions, Your Honors, only very briefly, because plaintiff itself caused the distinction between opinion and fact, largely academic and a non-issue. That said, it's difficult to understand how Alnylam's statements that the Apollo trial resulted in significant effects or achieved positive complete results are not, on their face, statements of opinion about the results of a clinical trial.
But can we say that, sir, on a motion to dismiss? I mean, couldn't one make the argument that there are objective statements of fact that the study showed that the drug had proof and efficacy to treat cardiomyopathy?
Respectfully, Your Honor, no, I would say no. Well, to answer your question, I think you can consider it on a motion to dismiss, and also I would say no, that's not what the statements say at all. They're very benign that the statements are positive effects or significant.
Well, but presumably the positive effects comes from the study, right? The study that studies the efficacy on the heart. So why couldn't one argue that that is actually an objective statement of fact?
Because 2 reasons. One, the study was focused primarily on polyneuropathy, not cardiomyopathy. So that's number 1. But number 2, I think as the case law holds that opinions like statements like that, including the Sanofi case, where a company said that a drug displayed a strong and robust treatment effect, was a statement of opinion. And here's why. And it makes sense because interpretations of clinical trial results are necessarily subject to opinion that reasonable people can disagree about.
So let's tie. I'm sorry. Go ahead.
How can you argue that a finding by the FDA that the research study offered by the defendant was inadequate because it failed to provide cardiac efficacy data? How can you call that an opinion as opposed to a fact? You're saying no, it's just their opinion that we don't have data. The data is either there or it's not there. Isn't that true?
It's 2 things, Your Honor. What does that mean? It doesn't have cardiac data. And I'll quote to the plaintiff's answering brief on page 28. What that means is Apollo's cardiac measures establish no clinical benefit. And whether a trial establishes a clinical benefit is inherently an opinion. But separate and apart from that, even if we take away the FDA saying, well, there's no cardiac data at all, I would submit to Your Honor that too is an opinion. And here's why. Because this is not a case, for example, where there were no measures of cardiac function or parameters. In fact, that's pled in the complaint. And the FDA report submitted in the record is replete with those references. And it's also not a case where Alnylam said they did one thing, but actually did something else. And it's also not a case where the FDA and here's the important point, where the FDA previously told Alnylam one thing, and then Alnylam said something at a later point in time that was different. And this is, if they had done that, then perhaps there's a claim here. But that's not what happened here. What happened here is Alnylam conducted a clinical trial. They disclosed what the measures were. Alnylam believed that they could seek approval for the drug. They did seek that approval, and the FDA, they granted approval for polyneuropathy, but did not grant approval for cardiomyopathy. That, Your Honor, I respectfully submit, is simply a difference of opinion and a non-actionable opinion at that.
See, I think that I could accept the argument if there was no study, but there was a study. So presumably there was a basis for that opinion that in X amount of cases, it had a positive effect on the heart.
Yeah.
Isn't that what makes it actually, at least arguably, a objective statement of fact?
I don't believe so, and here's why. It's there certainly were cardiac measures, and it's undisputed that the data that Alnylam disclosed to the public and also presented to the FDA was factually accurate. And whether the Alnylam believed that data was sufficient to demonstrate cardiac efficacy, and the FDA decided it was not, that is a quintessential opinion and not a statement of fact.
But you have 1 minute on rebuttal.
Thank you.
May it please the court. My name is Doug Willens. I represent Chester County Employees Retirement Fund. Justice Sherwood correctly held that our claims that we correctly stated claims under the Securities Act because we adequately alleged the registration statement contained untrue statements and omissions regarding patisiran's effectiveness for treating cardiomyopathy.
So counsel, just address, your adversary says those are opinions. Just address that. Why do you believe that at this point that it's sufficient to survive a motion to dismiss?
Well, it's our position, and Justice Sherwood agreed that these are statement of facts. There's nothing in those statements themselves that indicate their opinions, like in some of the other cases where it contains language like we believe or we think. It's a classic statement.
Well, can it be objectively, can it be measured? Is there some measurement to figure out whether or not that statement is true, for example?
Yes.
Or is it something that can't be measured, which would make it opinion, presumably?
Well, even I guess alluding to the second point, even if it is opinion, our answer is the result's the same, because the statement that omits material facts that a reasonable investor would then deem the opinion misleading. So whether it's a statement of fact or a statement of opinion, the answer is the same. And what it gets down to answer your question, yes.
We lost you for a little bit there.
I'm sorry.
Yeah, you're going in and out.
I'm sure.
I don't know. You're going.
Maybe I'm.
Yeah, you are going in and out. So.
There's a call-in also.
So a call-in number? Yeah, no, it's the end of the day.
Now you're good. If you can stay in that position, don't move.
I won't.
That didn't work. No, we lost you.
Let me That work? All right, well, would rest on my papers.
Okay. Sorry about that. Thank you. Thank you.
Thank you, Your Honor.
Counsel, you have 1 minute on rebuttal.
Thank you, Your Honor. I'll just address. I agree with counsel, that whether it's a statement of fact or opinion, the answer is the same. Totally agree. Because as I said previously, the FDA's opinion, the FDA's view, one FDA reviewer's view is itself an opinion. And lastly, counsel said the statements need to say, we believe. That's just not so. We cited to many cases that apply the Omnicare standard following Omnicare, and none of those cases require in a clinical trial setting, we believe or we think. And with that, Your Honor,
very much.
Thank you.
Thank you. That concludes the our arguments for today, April 7, 2021. Have a great day. Take care.
Thank you.